Lordship, I beg to mention for listing, Lordship, motion, Lordship. For motion, Lordship.
Motion, what's the subject matter? Raid?
It's a writ petition criminal, Lordship.
Raid criminal is to be listed before which bench?
Yeah, as per roster, Lordship.
This bench.
This bench.
What is the issue?
Issue is, Lordship, is a jurisdictional issue. The cause of actions are arise in Assam, Lordship. They have filed a criminal case at Calcutta, Lordship. The next date is 3rd of May, Lordship. How like, Lordship?
Your Lordship. Yes. With the consent of other side, I beg to mention item number 50 of today's list, Lordship.
50?
Some difficulty, some health issues are there, Lordship. I have to leave early, so matter may be taken up in the next two days.
Okay. This is for what?
For Cosman,
Cosmetic scan copy.
No, case diary was called for.
yes, there was called.
Wait, then you wait. Then wait. Any stay?
Interim order is there, Lordship.
Then we'll have to see. Case diary is written. We'll have to see.
I have some health issues, that's why, Lordship, I have to leave early.
Short date.
Yes, when?
Next week, any date, Lordship.
Next.
Appear corona. Informant appear one. Informant not yet appear, my lord.
Okay. Informant's presence may not be necessary. Who knows? Yes. On the prayer of Mr. M.K. Bora, learned counsel for the petitioner, matter stands adjourned and be listed on
Next week, my lord. 6.
6th of May.
Obliged.
Interim order passed. Will continue till then.
Obliged.
Lordship, I beg to mention item number 41. Today's list.
41.
Lordship, and this constitutes out of station, Lordship, and suffering from some neurological
Why this
problem.
matter is listed? IA for
IA, Lordship.
consideration of IA. You are for whom? Petitioner.
Yes, Lordship.
Petitioner. Petitioner. When? After a week. Yes. Next.
Lordship, I beg to mention one admission matter, criminal revision for GMA of a vehicle.
When Muslim?
Lordship, Thursday.
8.
Thank you, Lordship.
I'd like to mention item number 53.
50. Yes.
This is matter relating to third FIR, that is pending. That is when the other earlier two FIRs has been against the same plot of land. The CD has not received yet.
CD we have called for not received.
Huh?
CD not received.
Any interim order?
No.
No interim. Okay.
It may be listed after 2 weeks here.
The prayer of the petitioner after 2 weeks.
Obliged.
On 15th of May.
15th of May.
Obliged.
May please, Your Lordship.
Yes.
I beg to mention item number 39,
30.
not raised, Your Lordship. Matter become infectious.
39. The learned counsel for the petitioner submits that
69.
this matter has become infructuous. Accordingly, stands closed.
Obliged.
Interim order, if any, stands vacated.
Next, Your Lordship, I beg to mention item number 31.
Yes.
CD is not available, Lordship.
Any interim?
Yes.
From Vilasipara, on 30th of May.
38.
13.
13th May, interim to continue.
Yes.
May I please, Your Lordship, item number 5, Lordship, adjourn for the day, Lordship.
Huh?
Item number 5.
What do you want?
Lordship, Mr. J.N.M. Lashkar is not available today, that's why I'm adjourning, Lordship.
The prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after a week.
Much
May I please, Your Lordship, I beg to mention item number 21. Only matter will be fixed on 2nd of May.
21.
2nd of May.
21.
It's here.
LCM.
May I please, Your Lordship. I beg to mention item 19, Lordship.
May I pray for agenda matter for a week, Lordship?
Admission.
You are for petitioner?
Petitioner.
Petitioner, any interim order?
Lordship. Next date is fixed on 30th of May, Lordship.
Ah.
And if Lordship fixed the date before 30th, then
Okay.
no need to.
Give a date. Musubi. 6th of May. Interim order pass hole shall continue till.
Lordship, may I pray for another date? I will go for election voting.
9th of May.
May I please, Lordship, I'd like to mention item number 22, Lordship. Case diary is not available, Lordship.
Yes, sir.
My lord, next. 22. It is available.
Available.
এখন আগৰ 20 it is available. না না এখন আগৰ লিষ্ট আজি মাৰাই নাই।
Okay.
Obliged, Lordship.
CD, yes, yes.
Lordship.
Wait, Your Worship. I would to mention, with respect to item number 26 of daily list, Lordship.
Mhm.
Upon information I got that search sheet has been submitted in the case. And there is a interim order dated 28/11/2023, which was extended from time to time.
Charge sheet file,
Malati আসছে।
number is there?
CS number is 109/23.
And interim order dated
28/11/2023.
109/23 dated 31/12/23.
dispose of.
Next, Lordship. This application has been prepared under section 439 of the CRS matter. In this case, the petitioner has been forwarded my lord on 31/3 my lord. And as on today, my lord, 30 days my lord, he is behind the bar, my lord. My lord, kindly see the vernacular copy of the FIR, my lord.
We have seen that, but what to do? Call, we'll have to call.
Yeah,
for a
মানে
case.
Consulting party, my lord, the victim is 32 years of age. my
this case
lord.
Other allegations are also there.
Yes, my lord. And actually, see also, my lord, maybe perish, my lord.
Annexer,
See, my lord. It is another boy, my lord. Lecture,
Space.
page 19.
Page like 19, my lord. Lecture C,
19 my
again, on Farooq Abdullah, my lord.
17 is the
And-
type copy.
Annexure A, my lord, page 12, my lord, that is against the petition, my lord. Same kind of allegation, my lord. Within the period of 7.5 months, my lord, she became pregnant for 2 months, no,
Right.
2 times, my lord.
this FIR was also registered
Yes, my lord.
to the satisfaction of
CGM Dorong, my lord.
CGN.
Dorong. all the-
My lord,
I'll record your objection.
one line.
After reading the
Yes, yes,
FIR,
second-
I was
second.
convinced, but since there is some allegation, abortion and all are there, so I thought we'll call for the case there. But
Second,
looking at second to the satisfaction, objection to Lekhiba, considering the period of detention.
CGM all the way, my lord. Dorong.
CGM all.
Obliged.
Your Lordship.
Lekhiba also considered that there are 2 FIRs alleging same fact, but against 2 different individuals. Yes. Item number
2 mile.
2.
My lord,
FIR
FIR, space 14 mile.
14.
Criminal petition kita mau.
Hmm.
Baik to nine. Nine.
kindly see the paragraph, last paragraph.
Last paragraph,
Huh?
60,000.
Absolute abuse to the satisfaction of
CGM Kamrup.
CGM Kamrup. We'll record your objection. Don't spend government money on all these people. Feeding them, yes.
May I please, your lordship? Lordship, in the same FIR, lordship has called for CD,
CD and injury report,
lordship, on 8/5 in AB number 849.
8/5,
Yes, your lordship.
along with,
AB number 849/24.
where do I get that order?
No, it is not an.
No, no, AB number,
849/24, your honor.
Okay.
8/5,
8/5.
Eight.
Section.
much obliged.
CD 8/5.
Look here, my lord. The investigative officer has not appeared on 19 dates, my lord, 1 year, 9 months.
Yes,
That Antule case is there, my lord, but para 9 will prevail possibly, my lord, not 10, my lord.
yes, Gogoi, how can you expect justice if this is the situation? We want to know the cause from the Director General of Police. Blame will be on the court that matters are pending for years.
Yes.
This is the actual state of affairs. We are not taking it up in motion on Wednesday. You have your instruction.
From SP, my lord.
Where is this person posted now, or SP whosoever,
He is under suspension, my lord.
this man? But even if he under suspension for official purposes, he must be stationed somewhere.
Okay.
There must be an order for a part during the pendency, his office will be this.
Yes, possibly, it has to be
It
there.
has to be there.
Yes.
Heard Mr. Mahajan, learned counsel for the petition. The present application is filed under section 482 of the Code of Criminal Procedure with a prayer that no warrant has been issued against him.
No problem. No coercive steps have been taken by that.
Why?
Only someone.
Hmm.
46 is the first order of my lord
Uh,
summon, and 63 is the 19th order of.
People, so and so, so and so. Yeah, so and so, and so. With a grievance that the present petitioner who is accused in
My lord, CR case number,
Which-
GR case number 1059/14,
14 pending before
pending before my lord with all respect, Chief Judicial Magistrate Karbi Anglong Difu. my lord.
Karbi Anglong Difu. কি করলো? With a grievance that so and so has approached this court with a grievance that though he is facing a trial in connection with or he facing the trial, however, the investigating officer
My lord.
has not yet appeared before the court to depose
My lord, on 19 number of dates. my lord.
to depose
I'm sorry, my lord, 18 number of
on
dates.
continuously on 18 consecutive dates
My lord.
when the matter was fixed for evidence, for his evidence.
My lord.
First of, the material discloses that the initial summon to depose was issued on 18/7/2022,
My lord.
18/7/2022, and it continues till 30th of March 2024. Thus,
My lord.
almost 2 years has elapsed only for the deposition. Almost 2 years delay was caused only for non-examination of an witness. Such situation cannot be allowed to be prevailed in as much as a accused is also having a right of speedy trial.
My lord. My lord.
That being the position. Full stop. The aforesaid person is witness is an police officer,
Right.
and therefore this court will like to have an instruction as regards the policy of the prosecuting authority, that is the state police, how they are dealing with this kind of situation. Accordingly, list this matter on Friday. Learned public prosecutor shall obtain instruction from the Director General of Police, Assam.
The SP, I.
No, no SP,
They
no
actually-
business of
yes.
SP. Director General of Police, Assam. Do you need any assistance of either PP or
No,
senior
no,
government
no, no,
advocate?
I've taken steps, yes, no problem.
Full stop. List accordingly.
Highly obliged.
A copy of the order maybe, my lord.
Yes, we are giving.
Yes.
Yes.
Well, today is the date fixed there. No, nothing has to
Nothing.
be done. My lord.
এই কেসটো ৰাখিবচোন কোন হু ইজ দ্য চিজন অভিযান লগত কিয় হোৱা নাই
May I please interrupt? My lord, we have filed this case for quashing, my lord. My lord,
Quashing
case
of
is-
what?
my lord, case is this,
Item number
6. My lord, there are cross FIRs. That is phase 12 and 16. 12 has been lost by my opponent parties. That is respondent number 2. And 16, that is charge sheet, that is filed on, that is on the basis of the FIR lost by respondent number 2. And 21 is the charge sheet filed by my wife. Now, my lord, petition number 1 is an advocate at Obaibri, and he conducted a case of the husband of the wife of the respondent number 2. She asked me not to conduct the case, but I conducted, ultimately got acquittal, my lord. There is another case, my lord, same party, only cause of action is separate. That is, my lord, case number, criminal petition number.
where is the
4.
other FIR
My lord,
where is the other FIR
other FIR, my lord, that is, FIR is not annexed, but 21 may be seen, that is charge sheet.
why not FIR
That is charge sheet filed by, on the basis of the FIR filed by my wife, Shamsun Nahar Begum, wife of Abdul Manap, page 21. In this case, my lord, charge sheet has been filed against respondent number 2. And lastly, my lord, case has been compromised between the two parties. That lordship may kindly see page 28.
this FIR was lost by whom by your wife
By my wife,
against
against respondent number 2.
respondent number 2 and this is by
And this is by the respondent number 2. The FIR, which is at page
12
12, that is lost by respondent number 2. Similarly, my lord, they have also filed another case.
where are those
No, that is, my lord, in another case we have filed and further proceeding has been stayed. Lordship, this case number is 445,
please this matter along with
criminal petition number 445
445
oblique 2024.
up to 2024 on Friday.
My friend.
Will a motion will see it?
Yes, yes. Right. Obliged.
Decision
Yes.
230 application lordship.
FIR
FI is page 12 lordship. Lordship has an opinion of considering making FI on Friday lordship. passed the order.
where is that order?
Lordship.
Very interim
Highly obliged lordship.
within 2 weeks 10 days
Lordship.
10 days.
That matter is fixed on 13/5.
13/5 13/5 other matters out of same
Highly obliged lordship.
May please, Lord. Now, the FIR is at page 12, my lord. I am not named in the FIR. Section is 302. But my lord, the fact remains that FIR was filed after 3 weeks of the incident. The incident took place on 12/2. FIR filed on 5/3. And my lord, I am a student, nothing to do with this incident, my lord. And my higher secondary final exam was going on. Actually, on 12th, my lord, there was the higher secondary final examination.
CD.
Lordship will consider my lord student. My lord short date may be given.
Let us see the CD.
A date short. Kosugaon, this is Kokrajhar.
7.
7. 7 is a holiday.
Then 8.
8. Yes.
Yes, 9 is the FIR.
Phase.
Yes, 9.
Yes, Gogol.
It's 376, my lord. That's a-
376 we understand. Have you seen the 376 from morning?
It is true, my lord.
Huh?
Let CD come, my lord.
CD interim. Date.
16 May.
10.
May I please, my lord.
Yes.
My lord, is a 438 application.
Where is the FIR?
My lord, the FIR is at page number 32.
Phase.
Page 32. Starts from page 32, my lord. My lord, before my lord goes into the FIR, I'd like to submit that this FIR is a counterblast of a previous FIR, Jagiroad PS case number 298 of 23, which is annexed at page number 17, my lord, where the present informant was named as an accused. Along with me, I was also a co-accused. And now she had got anticipatory bail in the previous case along with me. And just 3 days after filing of the previous FIR, she filed the present FIR against the informant of the previous FIR. And I have been a co-accused in both the cases. And the other accused in the previous cases who have agreed to be the witness, they have been enumerated as witness in the present
In the
FIR. They have
first
been let-
FIR, both of you and the informant herein were accused.
accused, along with a few others.
Few others.
Yes, and the informant who is the brother of the deceased.
Now the FIR is filed by this informant against that brother who
Yes.
died.
And I'm also a co-accused. And the other co-accused who have agreed to be a witness in this case, they have been left out. So this is a counterblast, my lord. And the other co-accused are already on anticipatory bail. So, my lord, on the ground of parity, my lord, I pray that I may also be let out.
CD interim. When?
Interim then 15, my lord.
But strict condition that you will not condition you, huh? Not try to meet the informant.
I'm so obliged.
Or to or go near her property.
I'm obliged.
Yes.
438 and the FIR is at page 12, my lord. My lord, here in this case, my lord,
Phase.
page 12, my lord. 438, my lord. Here in this case, my lord, I'm a bit surprised, my lord. Bank has sanctioned the loan of 1.2, 1.12,
CD.
My lord, your lordship will protect me in the meantime. Because, my lord, I'm just praying for, because my mother is a cancer patient. I have to look after her. My lord, I may annex those documents. My lord, I will go and appear before the court, my lord, IO. Whatever they need, I'll supply that. This is all documentary evidence. 41A notice was not given to me, my lord.
This is not a case for case.
No, my lord, just for protection for my cancer patient, my lord. That's all, my lord. Till the CD comes, my lord. Till the CD comes.
CD. Next.
My lord,
Short date.
yes, 6.
6.
12.
May I please, your lordship?
Yes.
Allegation is that, lordship, we have,
Where is the FIR?
yes, lordship, FIR, lordship is at page number 12, starts from page number 12, relevant portion starts from page number 14, lordship. Is that we have misappropriated money, all are documentary evidence, lordship.
So
Let us
when
appear, Lord.
documentary evidence, no custody is required.
And Lordship, petitioner number
Some
one
other
to,
cases, we have not granted interim. here.
1 to 3, Lordship.
Where,
One
where
to-
are the cases?
That is AB
Parity.
1068.
Huh?
That is 1068.
We have not granted there.
Not granted, yes, Lordship.
CD
He fixed on 14th.
14th.
14th,
CD
then
on
same day.
14th. Same day.
Same day.
Yes.
Yeah, because it.
Go ahead.
FIR is case 13
Don't
lawsuit.
take case for interim.
Okay.
FIR is at page
13 lawsuit.
13.
13 lawsuit. Case 17.
Page 19. 17. Now, moment we grant you interim, you will do the same thing. We know
Actually,
that.
lordship, actually the
No,
complainant has lordship, Hardy lordship, wife of the petitioner number 2. And we have already submitted a representation before the commissioner lordship in this regard. Actually,
What? Wife of?
wife of the petitioner number 2.
Uh,
He was hurt by the complainant lordship. Actually, she was abused and with slang words lordship. And we have approached. First, we don't want to approach the police station lordship. They have assured that they make an apology, but thereafter they have filed this FIR lawsuit. Then we have approached the Jalubari police station, but they don't accept, and accordingly we have
with drug.
submitted a lawsuit. One only.
This is much more torture than beating a person.
Lawsuit, actual fact is
And you
lawsuit
will
distorting.
the moment we grant you interim from tomorrow, you will go and with a high court's order, interim granted
Lawsuit-
at wee hours, and you will start doing the same thing. We
lawsuit
know that.
actually-
That's why we are not granting.
lawsuit, that is not the
You
actual
should
fact
be,
lawsuit.
you should be in at a peaceful place.
Lawsuit, actually, it is
Robert,
not actual fact.
get hold of this man and keep him in some, send them to rehabilitation.
Lawsuit, it is
That is the,
not a custodial interrogation may not be.
No interaction is there, but for your interest, we are not granting you interim.
Lordship, may kindly where is this FIR lawsuit? We have already submitted.
That
before the
already
commissioner
seen, that already seen.
lawsuit. Lordship may kindly protect, he is the petition number was the employee of the NFL lawsuit.
That's why you should not protect much more.
Lawsuit, completely distorting fact lawsuit. Lordship may kindly see the lawsuit and that Caesar list lawsuit. In Caesar list lawsuit will find at page number 21.
Where is it 21?
Lawsuit, page number 21, lawsuit. This is Caesar list lawsuit. 2 persons were arrested lawsuit.
You are a railway employee and your daggers are seized from your vehicle.
This from the vehicle lawsuit. This is
You are
from-
also,
from the
specific
petitioner-
allegation, you
no,
played a police
petitioner number is the lordship. He is the contractor.
caught
lordship.
red-handed.
Petitioner number, lordship. Lordship may. Lordship may kindly.
Yes, Gogo, what if otherwise allegation is not that
yes, sir,
serious.
326, sorry, 323.
If we
interim,
submit lordship,
subject to the condition that the petitioner will not repeat such kind of action and will not go near the place of the informant. Moment we get in and also incorporate in the case, and the police will also incorporate in the case diary
Okay.
whether the petitioner has complied with the direction passed by this court today.
give lordship.
16.
My application, 482 application, my lord.
Yes.
The second FIR, my lord, regarding the second one, my lord, trial is going on, my lord, against the petitioner, my lord.
Where is the first FIR?
First FIR, my lord, page number, my lord, 15, my lord, 15 to 16, page number 15. It was filed, my lord, from the side of the petitioner, my lord, against the respondent number 2, my lord. After that, my lord, session number 2 file FIR, my lord, on 19/8, my lord.
This is FIR by
Petitioner, my lord, on 11/8/2019. And session number 2 filed FIR, my lord, on 19/8/19. My lord, after filing the FIR by the session number 2, my lord, within 1 month, my lord, mutual agreement was executed, my lord, between the both parties, my lord. For
this
withdrawal.
is first FIR,
Then, my lord, petitioner was waiting for the compromise. In the meantime, my lord, session number 2 filed another FIR, post FIR.
where is that?
My lord, page number 18, my lord. Main portion, my lord, 20. The 11 portion was 20. Page number 20.
Page
20, my lord.
20.
20.
Now, what this is
Now-
registered under what? 498A. Then
And my lord, both are enter a mutual agreement for withdrawal within 1 month, my lord, just within 1
where
month.
is that?
My lord, affidavit on page number 30, para 234. Affidavit shown by the session number 2, my lord, information.
Now you want
Page-
wanted costing on compromise.
Yes.
This is affidavit only.
Affidavit.
Where is the order?
Another, my lord, page number 33, on the mutual agreement was executed between the, among the both party, my lord. Page,
Who are petitioner here?
husband, my lord.
Okay, we'll issue a notice.
In the meantime, my lord, is the,
Considering it is an application under section 482 of the Code of Criminal Procedure 1973 for quashing of a criminal proceeding being PRC case number 2547/2019 pending before the Court of Judicial Magistrate First Class Kamrup Metro Guwahati. Guwahati, under section 498(8). Full stop. It is the case of the petitioner that both the parties, that is husband and wife, has entered into a compromise and settled their disputes amicably. Accordingly, the present application is filed for quashment of the proceeding. Full stop. Issue notice returnable on give a date. 27th of May, 27th of May 2024. Considering the matter in entirety, it is provided as an interim measure, it is provided that the further proceeding of the so and so shall remain suspended.
Right.
Steps within 5 days, both ways.
okay.
That is a lot.
So is the FIR.
At page 17, Lord.
Page
17, 17.
17.
Delegation is under section 302, Lord.
How many days you are behind, Ba?
56 days, Lord.
Huh?
56 days.
Yes, what are the case then?
So Lordship here, I will start with the inquest Lordship. In the inquest Lordship, in the description of injury Lordship, a round ligature mark was found on the neck of the victim Lordship. Thereafter Lordship, PM was done. In the PM, that ligature mark was not present Lordship. But there was an injury Lordship. Bruise of size 3 centimeter into 1 centimeter present over the left upper eyelid, black eye. That is in the victim. Now, Lordship, it is pending for FSL report. And as far as the investigation goes, Lordship, the neighbors have also stated that whatever happened on that day, it was done in a very silent manner, Lordship, because no sound was coming out from the house and they were acting very suspiciously. So, Lordship, and the husband, he is still absconding, Lordship. The present petitioners here are the father-in-law, mother-in-law.
Husband was not even present on that day.
Yes, that
Because
is
he
stated.
stays in Canada. He is working
Only
here.
the father-in-law, mother-in-law and sister-in-law were present at the
Hmm.
occasion. So Lordship, some more time will be required for the investigation, Lordship.
Reject.
Lordship, some more time may be given so that.
Lordship,
we can
Okay,
sort it out next week, Lordship.
it stays in this, consider, peruse the case diary produced. The investigation is at a very early stage. FSL and the investigating officer are also awaiting for the FSL report. In that view of the matter, we'll reject it or
Pending and
Reject
Huh?
it. Rejection will be better.
pending, see what is there in the FSL report, Lordship.
why should we keep this, it's a
Not
least,
really, even because for the last 6 years, there was no allegation on the part of the complainant
no,
that.
that is a different issue, but
Lordship.
apparently when there is an injury
Yes.
and no, no,
No, in a postmortem also there is injury.
Because
and no ligature mark.
Yes.
That gives a suspicion.
Yes.
Otherwise, it would have been a suicide. It's a,
But the
no,
ligature mark,
considering-
Lordship, is
no,
only
we
in
are
the
not,
inquest
keep
report,
it pending, let them file a press.
Lordship. Obviously, the-
On the next date we'll consider.
Lordship,
Uh,
Lordship.
Considering the matter in entirety, more particularly the stage of investigation and the allegation and the material so far collected by the IO, this court is of the view that at this view that petitioner has not been able to make out a case for grant of bail at this stage, in as much as their further custodial intervention may be necessary. Accordingly, it stands. Today is year 56.
56 days.
After 10-15 days, come here.
Lordship.
This proceed.
Lordship is rejected.
Rejected.
Lordship. All expected.
Lordship, case diary not received. It's from,
What is the allegation?
My lord. May I please your lordship,
Yes.
for the convenience of the court, my lord,
Mm.
may I pray your lordship to take up the matter 24 first,
2 meters are together.
my lord.
Okay.
he did not receive Lordship, it's from Sonapur. So a short date can be given, Lordship.
My lord. Item 24, my lord. 1146, 1146. Case number. FIR is at page 11, my lord. My lord, this FIR
Hmm.
is a counter blast of the FIR lost by these 4 accused persons. They have lost the first
How
FIR.
when can you have this case diary? When these persons were arrested?
My lord, 29th, free to already 1 month already behind the bar, my lord.
Is it Friday or Monday, Lordship?
Friday. Otherwise, Friday we'll consider
Lordship.
without you.
My lord, may I submit one thing, my lord? May this matter may be taken up at 2 o'clock because from the reliable source, I come to know that.
CD is here. So,
At 2 o'clock.
okay, let him use his reliable source.
At 2 o'clock, my lord.
At this stage, we do not have the information.
You have the information, we are not passing the order. If case diary is there, then we'll take it up the matter day after tomorrow.
Lordship.
Tomorrow, just inform us. Will
Lordship.
not, because he also needs a, see,
My-
if case diary is there,
Lordship,
let it decide.
At 2 o'clock, my lord. Or
if-
the day after tomorrow.
If
the
CD is here,
Yeah, yes.
we'll take it, this matter tomorrow.
My,
He will inform, orders will be accordingly.
Lordship.
my lord, my,
If not, then we'll take it up on Friday.
Friday.
my lord.
Okay,
Highly obliged.
you just have the information.
Lordship.
For bail hearing, I think 25.
25 Lordship, interim is there and CD has not been received, Lordship.
When?
10th Lordship.
10th of May, interim continue.
27.
Worship.
Yes.
In this case, I am appearing on behalf of this authority. Kindly pass over the matter.
Lordship, they are only interim, Lordship, and the IO has sent a communication seeking some time to
Okay.
produce the case diary.
When?
Since they are on interim, Lordship, can it be on 16 Lordship?
16th of May, interim to continue.
Oblige me.
Lordship, all these three matters, Lordship, can it be taken up after some time, Lordship? Pranjal Bhottakur, he will be
Okay,
appearing.
okay.
No, no, say, Lordship, it will be taken. Oh, Pranjal Lakuri, Lordship. After some time. Lordship.
After some time.
Yes, after some time. But yes.
May I please, your Lordship, I am on interim, I appeared, Lordship, my statement recorded, Lordship. I am a government servant, Lordship, FIR is at page number.
He did not receive, Lordship, interim.
He
is
did
there.
not receive
Interim continue.
interim to continue. When?
16, Lordship.
16th of
May.
May. Oblige, Lordship.
Lordship, regarding that matter, Lordship, we have received the information, CD is not there, Lordship.
Which that
That matter.
okay. So we'll fix your Friday. Just
Interim
inform it.
continue, Lordship.
Right. You have it. I don't think there is a fight between two parties.
Lordship.
Only anxiety is the 307 because allegations are serious, whether actually that happened or not. That
Friday, Lordship, Friday.
That's not. No, no, not 2024. You are talking about that, Mr. I 23 and 24,
Yes.
Friday. No. Yes, what is the status here?
Your Lordship, the petitioner is on interim. And Lordship, their statement has not been recorded, Lordship. It needs to be updated, the case diary. They are already on interim, Lordship.
But nobody is here. Last, we just wait for us.
Lordship.
Item 32.
32.
Wait for some time.
Lordship.
We'll just, after the bails hearings are over, we'll again call it.
Lordship.
33.
Yes, Mahajan.
I'm on interim, I appeared.
Where is the affair? CD is here?
Page 11 is there. 306,
Lordship, he has appeared and recorded his statement, Lordship. Lordship, there were some. Apparently, there was a release.
I now order for this. Stage of investigation cooperated. What is it? Absolute.
He did not
What
receive,
is it?
Lordship.
Only it down there.
Interim is there, Lordship.
Huh?
Interim is there, Lordship. He did not receive.
When?
Lordship, 17/5.
17 interim to continue.
35.
Lordship. 430 application, Lordship.
Sometime, Lordship, one of the PP has gone through it, Lordship. After some time, Lordship.
36.
36, Lordship, CD not received.
Okay, when? No interim?
No interim, Lordship. From,
CD and allow it medical report. Huh?
Lordship, from Dhubri, Lordship, 9th.
9th. Interim nahi, huh?
37.
37 is succeeded, my lord. Voluminous LC has come. I am going through, but
Okay,
No one.
Mr. Nan appears for the petitioner and call. To learn the additional public prosecutor submits that he has received the case diary,
LCR.
LCR,
Yes.
which is voluminous and want to go through the same. Prayer is allowed. Please this matter.
Friday or lordship's convenience.
Monday.
Monday.
38.
That is a lordship.
Yes.
438 application.
Huh?
Where is the 438 application? 2 fourth petitioner, my lord. Application, my lord, mainly around the 366. 364A and 386 extortion and kidnapping, my lord. And the affair would show, my lord, actually these accused persons, my lord, they used to sell, my lord, raw battle nut, my lord. This truck driver, he took it away and did not pay the money. So it was held up for few hours, my lord. Even affair would suggest, my lord, held up for few, he himself said it is the affair, my lord. This accused were allowed to go after some time, my lord. Panakala copies also, they are affair type of.
CD did not receive my.
CD not receive, my lord. That is the thing, my lord. Page 10 annexure A, my lord.
Okay, when?
On 10.
On 10.
Okay.
No interim, huh?
No interim.
40.
CD also from Gauripur, my lord, not received, my lord.
Not received. When?
Then on 13, my lord,
Any interim? No. 13.
13.
Supplementary item number 56.
May please, your lordship.
Yes.
My lord, in this matter on the earlier occasion, your lordship wanted to know whether, my lord, the police really approached the petitioner since the petitioner was shown as an absconder. With a charge sheet on the case diary.
No, Lordship had directed me to flag
Ah.
mark the, I have already flag marked Lordship, 3 occasion house search was done, Lordship. I flag marked Lordship.
One case, I have disposed it of in your case, in a similar, you said the similar circumstances, but while dictating we said it dispose it of.
Yes.
But while dictating the order, we noticed that in the petition, nowhere section is mentioned. Under what provision vehicle was seized. Not this case, I'm telling about some other, you were there. That is the case, na Muslim?
Phone. Banker.
Okay, so that order is not yet uploaded. We'll call it for to be mentioned.
Bank guarantee matter.
Yes. So in that case, you said similar. We also believe we passed this order similar. PP also could not notice it. Now, from the cause title to the prayer, there is no whisper under what sections offense was registered. We do not know what was the object of not mentioning the section. Second is we searched it and we found it that this is an seizure in terms of cattle prevention, smuggling prevention act. Now there is a statutory mandate for bank guarantee. If it is a statutory mandate for bank guarantee, we'll have to deliver it. We cannot say that magistrate has committed wrong. Can we? So therefore, it is for everybody, for the bar members. Faith should not be misused. We want fair, we like fair counsels. We will say that this is the provision. This is the law. Now, we are not saying that under 482, we are powerless to modify maybe a statutory prescription. We will not say we don't have. But under what circumstances, in what extent we can do it, we'll have to deliver it and give a reason.
Probably in that matter, I was not appearing, my lord, but I will inquire, my lord.
Huh? Who is? Huh? Who was there? S. Nawaz. You were not there. But your name is there. Your name is there in that. That's why I'm saying as a head. So we'll call it for, we'll recall the order. Since that's why we have not uploaded the order.
My lord, if we need to mention it, my lord, we can do it again.
No, that is not the issue. Issue is why you have not mentioned it. That is the vital link between the non-grant, because the magistrate also has not written in the order reflected that because of this provision, I am issuing bank guarantee. Simply said, we thought it's a normal case, bank guarantee has been granted. Yes, what is this?
Here, Lordship, on the last occasion, Lordship had asked me to pinpoint the house search notices, Lordship. I have already flag marked, Lordship. 3 times our house was searched, Lordship.
But in this regard, my humble submission will be, my lord, the power to declare somebody as an absconder is with the court, my lord. So, my lord, the case diary must reveal if any steps was taken by the IO to make any application before the learned jurisdiction magistrate.
You go to the magistrate. You say that police has declared, so you consider whether I am an. Go to the magistrate.
My lord, search sheet already submitted, my lord.
But you appear and say that I cannot be declared that.
But my lord, I inquired with the petitioner, my lord. I also asked if there was any document to show. My lord, she has submitted some documents, my lord. like medical prescriptions, my lord, NRC application. If your lordship wants, my lord, I can submit those documents by way of an affidavit, my lord.
No, no, what is the purpose of those documents?
Yes, so, my lord, that the person was in her residence in this intervening period,
No,
my
no.
lord. After the
That,
FIR was
that is
registered,
whether, now whom will you believe? They have given an issue with witness, signature of witness,
yes,
saying that on that date, so and so's house is searched.
yes.
These are the two, in presence of the following witness, two witnesses signed. This is one story. Other story is that this is me, I am here. Now, can we decide this, two disputed facts? That whether investigating authority is correct or you are correct. This is one aspect. Second aspect, you have argued that no, even if I am not there or you have searched it, this is the not procedure to declare me as an absconder. Why should we take that? Let the magistrate consider it on the basis of the record.
But since this is a sessions triable offense, my lord, so
Oh.
since we are concerned now only with the bail, so my lord, probably my lord, the committing court will not have the capacity to
Where is the law? Committal court is not having grant.
20918.
Grant bail.
2091A, my lord. So
I do not think that has been interpreted in different way.
that is the, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after a week. Yes, next case.
2018, 29. Pending matter.
নামটা কি ছিল? না না এই মাত্র কেস করলে Yes, which are the methods here?
28, 29 and 55, man.
Out of the same FIR?
Same affair, man.
Where is the FIR?
You will find on page 9, Lordship, of item number 28.
28. Okay, we are taking 28, page 9.
Page 9.
So tomorrow entry আছে না?
Some interim orders were granted.
Yes.
We have appeared, Lordship, and got the interim order.
Where are those interim orders? What is the material?
My lord, case they receive otherwise from the say FIR, my lord, this is not, this is my lord very serious offense from the context.
That's why we want to know, because they are on night duty.
Night duty.
They will have to protect the passengers.
Passengers.
If they are involved, then we will not grant them bail.
Otherwise, my lord, from the duty register is also, my lord, available in the case.
Huh?
On that day, they were on duty
Mm.
in that platform.
Mm.
This is a fact. But my lord, here investigation is also, your lordship may kindly see who are the actual, my lord, victimized persons. They were also not yet identified by the police, my lord. But
Now, how did they come to know that this is?
because one of the, my lord, home guard, my lord,
Mm.
on incident occurred on 28/11, my lord, on that night. Thereafter, my lord, he came to know somehow, my lord, that on that night, my lord, some incident happened by, my lord, threatening some, my lord, passengers. They robbed those, my lord, passengers, and thereafter, on the ground that otherwise to, my lord, they also demanded
So this is a allegation by another home guard.
another home guard.
Another home that this has been robbed by these people.
By these people.
These people.
And my lord, there subsequently thereafter all these, my lord, accused persons, they escaped from the, my lord, from their duty, my lord, since then, my lord. Thereafter, my
Okay.
lord, after obtaining interim order, they appeared and statement recorded.
Now, the actual victim,
Victimized persons not yet identified, and they have no, in fact, they also not approached before the, my lord, GRPF police station, my lord. This is the note of the, my lord. Who
so
are the-
maybe enmity between
Maybe, my lord,
maybe-
because victimized persons not yet
considering
identified.
yes, the material so far collected. The order দিছিল।
And from CCTV footage also, my lord, nothing is.
Consequent package there produced is produced. The petitioners were granted interim protection by this court under its order dated. Dated Full stop. pursuant to such pursuant to such protection, the petitioners had appeared before the petitioner had appeared before the investigating officer and got their statements registered. Full stop. They had also cooperated with the investigation. Full stop. The material so far collected in the considered opinion of this court, the material so far collected do not warrant custodial detention of the petitioner for investigation of the case, in as much as they have cooperated with the.
Otherwise, my lord, recently this type of offences is going on in railway.
That's why on
Yes.
that day also we express our view
Yes.
that if they are involved, if nobody has come and it is by one of the fellow
Victim or
colleague, we do not
person
know
involved.
what is his intention.
Yes.
So when there is a doubt in criminal case, it should be benefit should go to them. Yes.
Much obliged, much.
Dispose of these three petitions.
Please, Your Worship.
Yes.
Your Worship, pursuant to the interim order dated 22/3.
Where is the FIR?
We appeared and our statement has been.
Where is the FIR?
FIR is at page 18, Your Worship.
Lordship, after interim lordship, there's no note, lordship. We'll have to update the
Okay,
case.
learned additional public prosecutor submits that he may be granted 10 days time to get the case diary updated. Full stop. Prayer is allowed. List this matter
17/5.
17/5/2024. In the meantime, interim order pass earlier shall continue.
And May I have your Lordship?
Yes.
What is the 430 application, Lordship?
Hmm.
FIR is at page 14, Lordship. Petitions are on interim, they appeared
Same-
minus.
Same prayer, lordship.
Same
Same
prayer.
prayer, lordship.
Same date. Same date.
I'm agree.
My lord, this is a transfer petition, my lord.
Hmm.
By earlier order, my lord, notice was issued. We have taken step on 13/3, my lord. It was, my lord, I have collected the, my lord, tracking report, my lord. It says, my lord, it is delivered. It is delivered on 28/3/24. So may I pray, my lord, at this stage, my lord, the matter. It is between, my lord, son lodge complaint case against mother and his younger brother, alleging that, my lord, his father's pension money, etc., has been misused. My lord, this is the case, my lord, misused. And they are this mother, younger brother, and with the father, my lord, they are residing in the same family at Nagaon. Amongst other, my lord, the ground of, my lord,
Office note dated 25/4/2024 reflects that notice has been returned back after service. However, the signature acknowledging such notice is not legible. Full stop. The learned counsel for the petitioner has submitted a copy of track consignment, which reflects that the letter notice was served on 28/3/2024. Be that as it may, the learned counsel is permitted to place the aforesaid track consignment notice before the registry, appropriate section of the registry, and thereafter registry to put a note and list this matter after a week.
may I pray for, my lord, further proceeding may be stayed, because
When is the next date?
next date, right now, what I have no information.
Yes, next class.
And it may be
মাথা সব মাটি শেষ করেছে।
Your Lordship, as my senior is out of station, may we adjourn for the day?
It is submitted that Mr. S. Dr. Larned Senior Counsel is out of station. Accordingly, prayer for adjournment on his behalf is made. Full stop. MSB Chaudhuri Larned Counsel has not objected to such adjournment. Accordingly, matter stands adjourned and be listed
After 7th, my lord.
after 7th. Give a date. 9th.
9.
44.
None appears for the. This is an application for section 5 of the condonation of delay of 34 days in filing the connected criminal appeal. Issue notice. 4 weeks steps. Who will appear here? Any informant? Mr. Borthakur accepts notice on behalf of respondent number 1, 2 and 3, registered posts and usual process steps within 5 days.
45.
This is an application under section 5 of the Limitation Act for condonation of delay of 3 days in filing the connected special leave to appeal. Agoto to likhiba special leave to appeal. Full stop. Notice. Borthakur accepts notice. Notice 4 weeks both ways within 5 days. Extra copies to Borthakur. Yes, next. None appears for the petitioner on call. List after a week. Yes, Mr. Asadi.
My lord, there is an interlocutory application. Prior to that, my lord, I trouble your lordship to the FIR lodged in the 482 application at page 14.
This is IF for what?
I for stay of the proceedings because, my lord.
IF for stay of the proceeding. Now criminal petition is what?
My lord, the criminal petition, page 14 is the FIR, my lord. Both the husband and wife, my lord, are the advocates of Silchar Bar.
Hmm.
This is the application by the husband, my lord.
Good. They are using their all knowledge of law against each other. Let them sharpen their knowledge.
My lord. Thereafter, my lord, page 14, your lordship.
This is by
The wife, my lord. Page 14. My lord, page 21 is the court, trial court taking cognizance, page 21.
who is appearing for the respondent?
My lord, till now, my lord, you have taken steps. The issue is different, my lord. My lord, trial court took cognizance under 341, 294, 323. Page 21, my lord. Your lordship has got it. Page 21. Then, my lord, your lordship will turn to page 24. There is
No,
a,
no, go to that.
my lord, page 24 is relevant, my lord. This is a government notification for withdrawal of cases by the public prosecutor. Page 24, my lord. Because the next date is 2/5, my lord. That is why I have come with your lordship with the interlocutory application.
See, there is a judicial order, Mr. Rachaudhuri.
During that time, my lord, we could not place that.
No, Mr. Rachaudhuri, just look into this.
My lord.
A specific order is that the prayer for interim relief shall be considered only after service of notice on the respondent. Now, can I say that in view of this order, there is it's not that on returnable date. It will be considered on returnable date, we would have considered even in their absence.
My lord, returnable
But
time
a
has passed.
specific prayers or reliefs will be considered only after service of notice.
My lord, returnable date has been is
That
already.
we understand, only service of notice. Now you wait for the service of notice.
My lord, your lordship may give
Take a justice service.
my lord, only an observation, my lord, that we can file but no need of stay order, my lord. We can file an application, liberty given for adjournment of that day. My lord. That much your lordship will give it. The my lord, in the I, my lord,
Present
that
application petition under section 482 is filed by the petitioner assailing an order of cognizance dated 35/2023
my lord. But the learned session judge, my lord,
by the learned judicial magistrate first class.
then my lord, session judge at page 37, 29-24. Because the lady was not made a party. The only ground.
Whereby the prayer for withdrawal of PRC case number 2745/2019 was rejected.
Rejected because
Forget about rejected. We'll go to the because in later stage.
my lord, I bow down. My lord, I bow
Yes.
down. I bow down.
The further challenge is an order dated 29/2024 passed by the learned additional session judge FTC Silsar in criminal revision petition 96 of 2023 declining to interfere with the order dated 35/2023. Am I correct?
Correct.
Yes. Full stop. The office note dated, the petitioner and respondent number 2 are husband and wife. Full stop. The office note dated 26/4/2024 reflects that those steps were taken. Service report in respect of the respondent number 2 still awaits. Full stop. Accordingly, let the matter be adjourned and be listed after 3 weeks. After 3 weeks for service report. Full stop. Mr. Rachaudhuri submits that the matter is fixed before the trial court on 2/5/2024 and therefore an interim protection, interim stay may be, order of interim stay may be passed. Full stop. This court will await for service report till the next date and shall consider the interim prayer. Full stop. The petitioner shall be at liberty to file an application before the learned judicial magistrate seeking adjournment, and he is also given a liberty to serve notice upon the respondent number 2 through Dusty, which should be routed through the registry of this court.
Highly obliged.
What is this?
Let's say in this matter, Mr. P.C. Sethi was appearing a lot. So he has been suffering from eye infection. So maternity had John.
But what about the stand? We thought that will help the government in and all the litigants so far relating to compassionate appointment. So we started a process way back on 11th of December 2023. Now we are in mid of 2024. If government is not interested, we will release it from Part Heart.
Madam, next week, my lord, he is suffering from eye infection.
Where is Mr. Nath?
I'll inform you.
Inform.
Problem.
We'll pass order later. We thought of streamlining the process. Item 50. Yes, yes. Yes.
Maybe. Malad, in this case, Malad, the matter has been Malad, amicably settled between the parties. Now, my friend Malad, other side is not Malad, present today.
So we withdraw it, we'll close it.
Can it be Malad, posted after a week, Malad, so that Malad, the settlement has been made, but only payment is Malad, yet to be made.
That is the most important part of the settlement.
Let it be posted after
This
a
is a
week.
case for dismissal. You settle it. We dismiss it.
After a week.
Mr. Mondal, learned counsel for the petitioner submits that a compromise has been entered between the parties. Accordingly, he prays for an adjournment inasmuch as the learned counsel for the respondent is not present to assert in such contention. So, the list accordingly after a week. Yes.
Matter pertains to transfer of one criminal case from.
Yes, what you said.
May I please, Lordship, we have not yet received the petition. Because
Give a copy. Give a
I-
copy.
Lordship, may kindly see the last order, Lordship, dated, my lord.
We have seen that.
Lordship, there is an observation that he has to submit monthly maintenance of 10,000 miles.
They will come to that. You are without the copy now, you are insisting. You are either seek adjournment or will proceed.
Right now.
You cannot have both.
Right now, I'll have a.
Okay, the learned counsel for the respondent number 2. One or two? Respondent number 2 submits that he has not received any copy of the divorce is pending in Mongoldoy and this is filed in
The principal just family court. Petitioner is a blind person. Problem is there.
কি করলো press for copy of the copy of the petition. Accordingly, Mr. Mr. Saikia, learned counsel has furnished a copy is to furnish a copy during the course of the day. List this matter after a week. Interim order pass earlier cell till then.
May it please your lordship. My lord, I have challenged the impugned judgment and judgment dated.
Where is smiling? No confidence.
Lordship.
Huh?
Lordship, 8/2/2023 judgment was delivered, your lordship. So quantum of maintenance is 4,000, your lordship. So my submission before your lordship, I have filed the written statement before the lordship trial court below. My lord.
Then interim maintenance.
No, lordship. Finally disposed.
Where is that? Okay, now what is your grievance? Tell
My
us.
grievance is that you lost time. I am pursuing my studies, your lordship. So both the second party as well as the first party, the petitioner, happened to be the student of the same college, you become students, your lordship.
When?
It's a lordship.
When? Become student when?
2-3 years back, your lordship.
Now, become, then MCOM is also over.
No, lordship. What happens is that your lordship, after entering into marriage, your lordship, so she didn't come to the house of his parental abode, your lordship. So I tried my best to brought her back, your lordship. But what happens is I have stated in my written statement, she developed some illicit relationship with some other boys, your lordship. That has been reflected in the written statement, so that has not
We
been.
had this matter. Are you paying?
So lordship, I am paying you lordship, but my limited travel is lordship may be reduced to lordship to 3,000 rupees, lordship. Still I am a student and my father is also a government employee, lordship.
No, my lord, he is not a student, lordship.
Lordship, kindly have a look at page 14, Lordship.
Pay the price
So Lordship.
of marrying during student life.
No, Lordship. Only my limited submission before your Lordship.
Lordship, only 4,000, Lordship. Only 4,000.
Lordship, I am not denying to make the payment, your Lordship. My limited prayer before your Lordship is that my father, your Lordship. I am not a service holder, your Lordship. I am with my father. My father was a GOP employee. He got retired, your Lordship.
File an
Yes.
application under
Lordship, he is
127.
suffering from, my father is suffering
File an
from.
application under 127 saying that situation was my father was a service holder. Now his salary is reduced to half pension.
He was the service.
He was, now he's retired.
Retired.
So his 50% is a change of situation. File an
He
application
was
under
one
120.
CRPF employee, your Lordship, and he is suffering from illness, as well as the mother of the petitioner is also suffering from illness. So that may kindly be considered, your Lordship, since had I been the GOP employee, your Lordship, matter would have been different, your Lordship.
And what are you
So
doing?
3,000 may kindly be given, your Lordship.
Why don't you take her back?
I
Maintenance.
am expecting Lordship to get her back, but she is not coming, your Lordship. I have tried my best with the villagers, the elders also, your Lordship.
Lordship, Lordship, I have filed an affidavit in opposition, Lordship. That is
What a affidavit position. We'll decide whether order is correct or not. On the either we are admitting it for hearing, we'll hear it, call for the records. It's a final determination.
May be disposed on merit, your Lordship.
Dismissal.
Lordship may be on merit, 500 may at least, your Lordship, 500, your Lordship.
These are not our pause list after a week.
A date may kindly be given.
Give a date. Too many important matters are pending.
obliged.
13.
Yes. Huh? 13.5. It should not pass the stage of motion. These cases should not pass the stage of motion. Yes, next case. Same 125. Yes, what is your case now?
For respondent number 2, my lord.
Respondent number 2.
Lordship against the maintenance order, Lordship.
Interim or final?
Final. 15,000, Lordship. Page 10 to 18, Lordship. The judgment final order, Lordship.
What do you do?
Lordship, I'm an office assistant and I have a fair price shop, Lordship.
Office assistant and fair price shop.
I have an office assistant in a college, Lordship.
Mm.
My earning is 3,000, Lordship. And from fair price shop also, Lordship.
I'll not take up this 125 proceeding. On the prayer of the learned counsel for the parties, list after 10 days, 2 weeks. Give a date, give a date. It will adjourn, no? 20.
It's a Jimma, my lord. 29 cattle, my lord. My lord, earlier occasion, the case came up before Lordship, my lord. So I was granted interim bail, my lord, from this court.
That record.
Yes, my lord, the CD is available. The case diary available in the case diary, my lord. Yes, my lord, there, my lord, receipts are also available. Out of 29 cow, 1 died, my lord.
Anyway, at least give him the
My
28.
lord, only fact is that earlier it was rejected, the order is, my lord, I was investigating. Now, only one thing I, my lord, want to show you, lordship, that
Bank guarantee.
no, not the bank guarantee, but as per the act, my lord, section 11(5).
Give us the act.
Except cattle, cattle is prohibited. Not Jimma. This Assam Act, my lord.
Assam Act.
Assam Act.
Section?
Section 11, subsection 5. Power to enter in the institution beside on receipt of report, my lord, start.
Section 11.
Section 11, subsection 5. On receipt of
Prevention of Cruelty Animal Act. Assam Act. This is not that.
the
Bank guarantee given, hai to.
no, bank guarantee except cattle. My lord, I am reading and my lord may give, I am
Huh?
giving this. My lord,
Huh. Assam, yes. Assam Cattle Preservation Act 2021, isn't it? Okay.
There, my
Section
11, subsection 5.
Section 11, subsection 5. Okay.
On receipt of the report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that prima facie offense under this act has been committed or intended to be committed, release of the seized materials, including vehicle convenience, except cattle.
That has been deleted on 28/1/2022.
This I'm.
That has been deleted. Omitted by Assam Act of 2021 with effect from 28/1/2022.
Very good, sir. No, এখন কিতাপ নাই না। No, এখন কিতাপ পুরোনো হয় জানি।
Rules খন কেতিয়া আহিছে কোৱা? EP হয় তোমালোকে জানে। কেতিয়া আহিছে কোৱা?
Mr. Dotto, let the cattle be there for some time. We want to address you on the provision of section 5 vis-a-vis our power under 482. See, it's a statutory mandate. Statutory mandate is this. Now there are two words. One is a may. Judicial magistrate may. Okay. Now whether may will relate to power of release or may also include power not to insist on back guarantee. This is one aspect. Okay, you read it. Furnishing of a bank guarantee, to be committed release of seized materials including vehicle. Prisoner check has been committed. Release the seized materials including vehicle conveyance, cattle on furnishing of bank guarantee equal to the value of material or vehicle conveyance except to the satisfaction of the court pending disposal. Now, there is a condition of bank guarantee. Now, whether this bank guarantee this may will include to the prescription of his power to release under subsection 5 of section 11, and this may will also relate to his power to not to insist on back guarantee.
I understand.
Because in many cases, magistrates are mechanically saying straight away, bank guarantee. Well, bank guarantee concept has been, Supreme Court says that this is in many cases. Now, how to interpret? Because it's a statutory prescription.
Yes. Day after tomorrow.
Day after tomorrow. Heard at some length. The learned public prosecutor has submitted that in terms of subsection 5 of section 11, even if this court is inclined to grant Jimma of the seized cattle, it is the prescription under the aforesaid section that this court is to direct furnishing of a bank guarantee equal to the value of the cattle. Mr. Datta, learned the council submits that he may be granted time till Friday to address this court as regards the phrase word used in subsection 5 within the word within subsection word within brackets inverted comma may used in subsection 5 of section 11. List it on Friday. Heard.
Lordship, in this case, I made a mention for listing of this matter. If your lordship permit at the end of the list or day after tomorrow, lordship. Some preparation required.
I am for my lord respondent 2.
The
The issue is
that
very simple, my
lordship
lord. Issue is very
power
simple.
authority issued the check and the owner of the shop was filed, NI Act was case against an owner of the shop, lordship.
Actually, eventually, my lord, check was, my lord, from the account of the petitioner. Page 31, in his name, Highway One Shop.
But
Now, my lord,
signatory is the
authorized
power of attorney.
signature is shown. So whether authorized signatory was empowered during this relevant time and demand notice was also received, there is no any reply. Admitted fact that he issued the
So
check.
your case is that if bank has permitted to issue me a signature, signature or the issue of
Yes.
check on the basis of a power of attorney, then it will be binding. This is your case.
But the question is, my lord, when
While
demand notice.
issuing notice, I cited a decision of Kerala High Court, Lordship, which says drawer and drawee, Lordship, on that basis, who signed the check, Lordship?
Account belongs to you,
Yes, Lordship.
is not
In
it?
the name of the shop, Lordship.
In the name of the soul. You have given power of attorney to issue a check also,
To sign.
to sign a check. Now, where is the difficulty here?
Lordship, in the name of the shop,
Then there will remain no sanctity of any power of attorney.
Lordship.
There will be no sanctity of power of attorney.
On that count, Lordship, power
And-
of
and
attorney.
Lordship,
On the prayer
and-
of MS R. Chaudhuri, learned counsel for the petitioner, matter stands adjourned and be listed on next week.
And
may
and
be
lordship,
Lordship.
so far, my lord, citation.
No, she is seeking an adjournment today. So that's why you're adjourning it.
My
What?
name, my name is shown.
Mr. Bhuya is present for the
Respondent number 2.
respondent number 2. Uporte diba. Next week. But at thereafter, 17th of May. Interim order pass earlier shall continue till the next date of list.
I'm deeply obliged.
কিমান আছে? মাতাচোন মাতা চাওঁ।
47.
সেইটো matter, no? Mr. Chaudhuri, we'll take it up a little bit later. Oh. Are you going for disposal? Yes, so we'll just take it.
48.
Made please, your lordship.
Yes.
Lordship, this is a 482 petition praying for crossing of an FIR. Lordship, the FIR reveals my lord out and a civil dispute. And on the same set of allegation, which is in this FIR, to that effect, my lord, one title suit is pending.
What is the affair?
Page 17.
Page 17. May I read, lordship?
Yes.
Dated 1st February 2023. Complainant so and so and the accused person so and so. Number 1, Srimati Jahanara Rahman. She is the petitioner before your lordship. My lord. My lord.
All are represented, all respondents are represented.
Respondents are represented.
No. I am representing respondent number 3.
Who is 3?
3, my lord,
My lord,
Lot Mandal. I am not representing, my lord.
My lord, these are not made party. My lord.
Why?
My lord, I am seeking my lord crossing in regard to me. My lord.
But understand, but okay. Okay, they are also accused. They have not come for purpose. You are the
Wife of the my lord doctor.
you are the you are that is accused number 1. Who is accused number 2?
Accused number 2 is a Lot Mandal.
Okay.
And
2 and 3.
2 and 3.
Okay.
And 4 is the my lord FD, MD, MM Sodor Kazi. My lord, this Sodor Kazi, my lord, issued a my lord marriage certificate as per my lord, and therefore my lord, he was made as an accused. And these two, my lord, accused number 2 and 3, my lord, they have made their report for passing a mutation order. Accordingly, circle officer was passed the mutation order. but circle officer was not made as an accused. My lord, page 18, my lord.
Yes.
Paragraph 1, the complainant is a citizen of India by birth and a local resident of the aforesaid address mentioned at the title of the complaint within the district of Jorhat, Assam. The complainant is a reputed businessman and one of the legal heirs of one late Dr. Ahmed Hadiur Rahman since deceased. This, my lord, Dr. Ahmed Hadiur Rahman is the husband of the, my lord, Jahanara Rahman, the petitioner before your lordship. The complainant has filed an instant complaint against the accused person for criminal trespass, fraud, cheating, misrepresentation, and forgery. The accused number 1, Jahanara, is the niece of late Ahmed Hadiur Rahman and daughters of late Muhibur Rahman and Nur Nahar Begum. That the accused number 2 and 3 are the Lot Mandal and SK respectively, presently working at Titabor Revenue Circle, District Jorhat, Assam. That the accused number 4 is the Sadar Qazi of Nalbari, Assam. That one Dr. Ahmed Hadiur Rahman during his lifetime was working as doctor on the post of SDM and HO, the Health Jorhat Joint Director's Office, Old Civil Hospital, Jorhat. That the said Ahmed Hadiur Rahman expired unmarried on 29th day of July 2021 at Titabor Subdivisional Civil Hospital, Titabor District, Jorhat, Assam. That at the time of the death of late Ahmed Hadiur Rahman, he was unmarried and survived with the following legal heirs. Well, their stand is, my lord, they are unmarried. He was unmarried, and the legal heirs are Motiur Rahman, Sahidur Rahman, Abbar Mosbim. So these are, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. That after the death of late Ahmed Hadiur Rahman, the complainant along with the other legal heirs on 9/8/2021 had obtained the death certificate from the competent authority and have also obtained the Gaubra certificate, who knew the names of the legal heirs of late Dr. Ahmed Hadiur Rahman. And in the said Gaubra certificate, it was also mentioned that the said Ahmed Hadiur Rahman expired unmarried. Thereafter obtaining the death certificate and Gaubra certificate, the complainant appellant for obtaining the NOK, next of kin, from the concerned authority, and after thorough verification and going through the documents, the concerned authority have issued the NOK mentioning therein the names of the legal heirs of late Ahmed Hadiur Rahman since deceased. So, my lord, the late Dr. Ahmed Hadiur Rahman died on 29/7. Thereafter, my lord, they have, my lord, procured the death certificate on 9/8/2021, that is within 11 days. Thereafter, on 6/12, that is within 5 months, they have obtained the next of kin certificate in their name. Here your lordship will not find my name. Next, death certificate enclosed, Gaubra certificate, NOK was also enclosed. 7, that the said Dr. Ahmed Hadiur Rahman was the owner, recorded pattadar, having right title and interest in respect of a plot of land measuring 2 bighah 3 katha 8 lasa, covered by DAG number 1078 of PP number so and so, along with buildings standing thereon, being situated at Titabor town under Titabor Moja, Titabor Revenue Circle, District Jorhat, Assam. A copy of the Jamamandi is enclosed herewith as annexure 4 to the complaint. My lord, this is the self-acquired property, my lord. And that after the demise of late Dr.
Where is the plaint?
My lord?
Where is the plaint?
Plaint is at, my lord, the page. Page 61, my lord. This is also filed on the same day, my lord, 1st February 2023. Filed by the same complainant as plaintiff, Hassan Khalid Haider. And I was made as defendant number 1, Jahanara Rahman. Page 62, my lord, may kindly see. Suit for eviction, declaration, cancellation of mutation, and for injunction, both permanent and ad interim. And my lord, may kindly see the relief at page 71. Page 71. 71. The plaintiff claims judgment and decree declaring the suit in favor of the plaintiff. Decree be passed for eviction of the defendant from the suit property. Decree declaring the defendant has no legal status as a wife of deceased late Ahmed Hadiur Rahman. A decree for cancellation or mutation of the defendant pertaining to suit property in the record of rights. A decree declaring the plaintiff and the pro forma defendant number 2 to 13 as the legal heir of the deceased late Ahmed Hadiur Rahman. A decree for recovery of khas possession of the suit property by evicting the defendant number 1, her main and materials from the suit property. A
Yes,
decree-
Gogoi, are you having the case diary?
Yes, yes.
We'll come back. Yes,
Lordship,
civil dispute.
Lordship, one thing, my lord, one thing, my lord, the mutation was done on the basis of a marriage certificate. And that marriage certificate itself is a fake one, my lord. Oh, my lord,
Mayor stating that this is a fake
No, no, Lordship,
certificate. No specific please
No, no,
statement as regard food. Okay, we'll come back to Mr. Nath. That matter. We thought this will help everybody,
Correct.
but nothing is.
But Lordship, in the order dated 11th of
Ah.
November, Lordship has in detail.
I
has
have,
mentioned-
we tried to do some work
correct.
for you and for the litigants,
True.
but government's response is very poor.
In fact,
See, from December, we are in this matter is being kept as part heard.
Correct.
We thought that we'll do something about this huge bunch of litigation on this compassionate appointment.
Ultimately, to that level, what I have gathered, to that level, nobody has done. Because 2 years period, as indicated by your Lordship in the order, that has not been ultimately.
So ultimately, there is inconsistencies in order by different courts.
Because
That's why we thought we'll streamline it if possible. But government, there's no help from the government.
Because the waiting list also cannot go beyond 2 years. Because 2 years is the time.
So have what they say, and there are some prescription, waiting list. What is the waiting list? For how much days you will keep it as a waiting list? Is it not in contravention with? So you must be clear that if it is in waiting list, this person will be considered in that way. Only for somebody's satisfaction or and many applications we have seen that 3 persons applies. 1 person's application will be kept in the dust and 1 person's application will be taken from the file. So is there any prescription to make the seriatim of the claim? Because that is the fundamental, one of the vital consideration is that urgency.
No, no.
We are dismissing petitions because no, you have already passed 2 years. Forget about your completion.
In case of compassionate appointment, my lord, the seniority of the application is not a criteria. It is
No.
ultimately amongst all the applications.
No,
the
no, that we
financial-
understand. That we understand. That
financial
is not.
criteria. That has to be.
The stage of till the stage of consideration. We are not saying the consideration is a seniority.
True.
Up to the consideration.
True.
You are hundreds of pending applications pending.
Yes,
Now it will be given to a committee,
yes.
district level,
District
then
level.
state level. You will see many applications are pending for years,
Nothing.
not even placed for consideration.
In fact, I have also seen in some cases, those applications even for 5 years, those are not placed because some required informations are not available.
But there must be something on record.
The department concerned, ultimately the administrative department concerned.
So
they have to
therefore,
provide-
what is happening is a person will come and
After-
will say that my application was pending.
Yes.
We'll say them what you have not pursued. What should we do? But ultimately it was pending at your stage.
At our-
So suppose there are some documents where there are some requirement of certain documents.
Yes.
Intimate to him also.
But those applications
See,
are.
this government is spending too much in this litigation.
Well, in fact, in an application of 2004, it was considered in 2020.
2020, suppose there are some messages are sent, please give this document, give that document. This is not being given. Intimate to the claimant also, because he should know that my application is, or you make a format that until and unless these are not given, you will not forward even. Then he will be aware of this, that my department asking me these documents I'll have to give. Or most of the documents except the family status are with the government, with the employer. So we thought that we'll streamline it. The government, I think, is not interested. Maybe this may be source of something to keep some files up and keep some files down. Who knows? And in the process, too much of litigation. This compassionate appointment has traveled this court for twice, thrice, even more than that.
Repeatedly.
We'll send it back because we have no option.
Correct.
Some contempt will be filed, then they will pass a speaking order, nothing on that, again a repetition, again somebody will return. So that we thought we will streamline it, but government is not interested.
Otherwise, my lord, the very purpose of this compassionate appointment itself is having no value.
We know we know the law, that it should not be delayed. It's an emergency.
Correct.
But at whose end this is being happen? So then it will be a giving license to the government, keep it pending. Court will, if you can delay it, court will say, okay, you have survived your initial things, you seek a compensation from the government for doing wrong, but we cannot direct for your compassionate appointment. This will, so that we thought, so what to do in this matter?
But
I called you because I thought I'll release it from part third.
But,
That was my idea, because what to do if you are not helping the court?
the intention on our part is to definitely
Not
because-
saying you or Mr. Sutia,
But-
you are doing
but-
your part, but if they are not interested, government.
because the query what lordship has recorded in the order, that itself indicates that there is some discrepancy.
So
and
let them have
ultimately
it,
the
then we'll
decision is not-
expand it, we'll go to the
Correct.
further scope.
Correct.
Maybe we may consider his claim on merit and then we'll take it as we'll proceed with the writ petition, passing an order.
Lordship.
So you are adjourning till when? After election, if you can possibly do it, then otherwise we'll record it that we did not get any assistance from the departments. This is the state of affairs. We'll record our thing and release it from part.
Lordship may
So it should be on record that
Plus-
we have given a try to do something for the litigants as well as for the government to streamline something, but government is not
Well,
interested. So we'll record that.
But even some affidavit, the affidavit doesn't come along. On the basis of available materials, Lord, whatever is seen, on that basis.
No,
Lord,
that we
make-
can decide, that is nothing. We want to that, so that in the process, in deliberations, the issues that are being involved, those
From
comes out
records,
and we
from
can give us. The
Correct.
second issue is as regards that waiting list. What should be the waiting list?
In fact, Lord, clause
5,
15, Lord,
15, additional clause 15.
clause 15, it indicates that, look, that was brought because in the earlier, Lord, before 1/6/2015, the 5% of the vacancy, now it is 5% of the cadre strength.
Understand?
So, Lord, already when they have already filled up post on compassionate
No,
appointment,
that we understand that you have a reason,
that is
but
why
but will you keep it? I will ask the SARS for any other departments or
Department.
something like that. Then
that
keep
cannot
it till
that
waiting.
cannot be indefinite. That cannot be.
What is the period? That is silent.
That is silent. That is silent.
That is what.
And they said that
You will not say that you will not have a power to expand to that or kedar and all. There is no issue on that.
Look.
But issue is to which date? From waiting list for already delayed. Then after, then meaning of waiting list, then whole compassionate appointment will go.
it goes. It goes.
If
Correct.
as one date, somebody is not having, it's a luck, kind of a lack of luck and chance. If no vacancy, no vacancy. It's not a right as such that he can continue and put him for years. His on a date when his right is when his case is considered, on that date the requirement was not there. Can you postpone it? If that is so, you will have to make a strict seriatim so far relating to consideration. In a case of consideration, serenity will not come. It will come the merit. That who is in a what position? A person is having 100 bighas of land and one is not having anything.
Lost.
So he may die earlier, but his family will get preference.
He will get preference.
But at the time of consideration,
True, true.
so these are
Consideration
not
has to
clear.
be- Consideration
Anyway,
has to be
on the
quick.
prayer of
Quick.
Learned State Council, matter stands adjourned and be listed on give a date. They will not postpone thereafter. May second part,
May, my lord,
20 after 20 days,
2021, my lord,
21st of May.
21.
Part heard. We'll see on that day. If possible, we'll proceed, and if nobody is interested, we'll stop there. Yes. 5 minutes break. Mr. Chaudhuri, it may take some time. So at 2.
Lordship, I was reading page 21.
No, I understood. From now, what is your case?
My lord, they have said that on the basis of the marriage certificate issued by Registrar Muslim Marriage and Divorce Nalbari.
She got the mutation in her name, being declaring herself to be the legal heirs.
Legal heir.
Whereas she is not a legal heir. In fact, she is not a wife. She is a niece or something like that. Anyway, this is their allegation.
This is their allegation.
And they say that this is a fake certificate.
Yes.
Now, what do you deal with that part?
But admittedly, my lord, this particular document, my lord, section 463 talks about forgery. Whoever makes any false document, or false electronic record or part of a document or electronic record with intent to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with property, or to enter into any express or implied contract, or with intent to commit fraud, or that fraud may be commit for forgery. So, my lord, whoever makes any false document, here admittedly, my lord, the marriage certificate was issued by Registrar Muslim and Divorce Nalbari. I am not the maker of that document. So, my lord, section 464, 463 and consequent punishment under section 465. 464, making of a false document. Definition, my lord. A person is said to make a false document or false electronic record first, who dishonestly or fraudulently.
Then,
so, my lord, this 465, my lord, does not attract against me. And my lord, on the basis of this marriage certificate and also on the basis of my possession, my lord, mutation was granted in my favor. And when the mutation was granted, they have immediately challenged it before the appellate authority, that your lordship will find at page number 89.
Page number 89.
Page number 89. My lord, I am reading, my lord, 29/12/2022 order. The application dated so and so filed by Sri Hassan Khalid Haider. This is the, my lord, the complainant, son of so and so, Jorhat, filed this application and appeal has filed under section 147 of the Assam Land and Revenue Regulation for cancellation of mutation.
this is order of Board of Revenue or the appellate DC?
ADC, my lord.
ADC.
Additional Deputy Commissioner Revenue. This is still pending. Page number 90. Therefore, on the basis of the application made by the applicant, a revenue case should be registered, notice to be issued to both the parties for hearing. So, my lord, this is also pending, my lord. And my lord, they have, my lord, filed the, my lord, this, my lord, title suit, my lord, against me. That was also on the first day of February 2023. And there, my lord, the relief, my lord, what they are seeking, my lord, a decree declaring that defendant has no legal status as a wife of deceased. So, my lord, I am not the maker of the document. And my lord, on that issue, my lord, whether I am having a legal status of a wife of the deceased or not, to adjudicate that issue, my lord, the title suit is pending. So, my lord, on the same set of allegation, my lord, this, my lord, criminal, my lord, this complaint, my lord, it's a totally, my lord, civil in nature, and they are trying to give a criminal texture on it. So, my lord, Supreme Court as well as our High Court, my lord, in very clear terms, my lord, held, my lord, while exercising true judgment, I just want to rely. First one, my lord, Naresh Kumar and others. That, my lord, paragraph 6. In the case of Paramjit Batra versus State of Uttarakhand, so and so, this court recognized that although the inherent powers of a high court under section 482 of the Code of Criminal Procedure should be exercised sparingly, yet the High Court must not hesitate in quashing such criminal proceedings which are essentially of a civil nature. This is what was held. 12. While exercising its jurisdiction under section 482 of the code, the High Court has to be cautious. This power is to be used sparingly and only for the purpose of preventing abuse of the process of any court or otherwise to secure ends of justice. Whether a complaint discloses a criminal offense or not depends upon the nature of facts alleged therein. Whether essential ingredients of criminal offense are present or not has to be judged by the High Court. A complaint disclosing civil transactions may also have a criminal texture, but the High Court must see whether a dispute which is essentially of a civil nature is given a cloak of criminal offense. In such situation, if a civil remedy is available and is in fact adopted, as has happened in this case, the High Court should not hesitate to quash the criminal proceeding to prevent abuse of process of the court. So, my lord, in the title suit, my lord,
Okay. Yes. Abdullah.
Lordship, may kindly turn to my lord, page 101 running page. That is my affidavit, my lord, in this 101 running page. My lord, one of the legal years, my lord, he has made an RTI query before the Kaji office. From Titabor, a person went to Nalbari. He made two specific queries, my lord. Page 104, my lord, is the answer of the Kaji. Answer, my lord, the answer proportion in the bottom.
Marriage was solemnized in Nalbari.
A person from Titabor, they have saying, we are saying there is no marriage. Even the Kaji have said that answer the Kaji, page 104, answer, my lord, the portion lordship has got it. Nobody went there, my lord, for marriage. So, my lord, that's why we made a Kaji also an accused.
He being an accused.
Just ask him. Yes, sir. Gogoi, any proceeding further?
My lord, here, my lord, the diary statement of the Kazi is here, my lord. If your lordship it peruse that.
And page 116, my lord, she herself stated that she is an uncle in her mother death.
I am not denying, my lord. Subsequently, I was married to her. And there is no bar as such.
This is the statement of
Kazi. Lordship may see, my why they will go to Nalbari for marriage.
statement of this lady is recorded.
Yes, that is also there, my lord. I have flag mark not, one accused that Jahanara. That Jahanara also says that no, formal marriage not took place, my lord. That mutation, now they are challenging mutation. Mutation was done on the basis of that marriage certificate, that she is a wife of that deceased. That is-
And page 116, my lord, when she has applied for the death certificate.
No, I've seen that. She
No.
had admitted.
Yes, my lord.
In her statement, she said that since nobody was recognizing me as a wife, so I applied this, and admittedly, this is the relation. And marriage was solemnized only for the purpose that she can become the legal heirs.
But Kazi has not seen bride and bridegroom.
That's why we have made the Kaji, my lord. He issuing the certificate itself a fake one, my lord. We never went there, my lord.
My lord, page
That's why we made a.
49 may kindly be seen.
Page?
Page 49. My lord, I am not denying, I am his niece, my lord. That is an admitted fact. But my lord may kindly see page 49. Marriage certificate. Government of Assam, Office of the Sadar Kazi, Boroma Road, in front of DC Office, Nalbari. Marriage certificate. First party, Dr. Ahmed Hadiur Rahman, aged about 60 years, so and so. Address, Titabor. Second party, Jahanara Rahman, aged about 49 years, so and so. This is to certify that the marriage was solemnized between Dr. Ahmed Hadiur Rahman.
The creator has denied in his statement.
My lord.
The creator of this certificate has denied in the investigation that no, I have not, no marriage was solemnized. But one of the lawyer who comes and says that this is an authorized marriage, on the basis of this, please issue a certificate.
My lord, admit, then therefore I am saying, my lord, that means, my lord, they have issued, my lord, the certificate, my lord. On the basis of that, my lord, that their marriage was solemnized on dated 5/4/2018 by Islamic Shariat law in presence of Nayama.
So, okay,
Nayama Rahman.
468, you say that I have not forced it.
I have not forced
But
it.
if there is a conspiracy and to grab a land, there may be some other offenses. They may not file a charge sheet under 468.
My lord, may I say,
So at this investigation, should we stall the investigation?
my lord,
Case is not made out. Yes, if we go by your argument, no case is made out. Because there is a specific allegation is required that you have a role in, you are the author or you have forged the documents. So far relating to the maker of the documents or electronic documents,
Yes.
you should be the author.
Yes.
But the FIR cannot be the gospel truth.
FIR cannot be the gospel.
So
truth, my
let
lord.
the investigation continue and it will be closed by FIR or whatsoever.
But my lord, may kindly see one thing, my lord. In my, my lord, the page.
See, from the materials available on record, we do not think that this is a case only of civil nature. There may be some other criminal angle.
But my lord, what they
May
are
not be
seeking, my lord,
468.
what they are seeking, my lord.
May not be 468. May not be. But in Niharika, it has clearly been said, why should we stall the investigation? That's why I said, let us see the case diary.
My lord, may kindly see page 57.
Yes?
57. This is a report from the. This is a report from my lord circle officer. With reference to the subject and reference cited above, it is to inform you that mutation in favor of Srimati Jahanara Rahman was passed as per the official rules and procedure and also as per Assam Land and Revenue Regulations. In this regard, it is further advised that if any party has any grievance, they may approach the civil court.
No problem.
In respect of the said mutation, the following information is submitted below. The applicant has furnished the death certificate of Dr. Ahmed Hadiur Rahman. As per report from the Mojadar of Titabor Moja, the applicant has been regularly paying land revenue of the said land.
No problem. On
As
you
per the-
enjoy the land, let them get you evicted, let them get there. We are not concerned about this. We are not at all concerned. If court can give a decree on the basis of the certificate that you are entitled for mutation or you are the legal wife, that is one aspect. Court may say that
Civil court may say.
Civil court may say that the marriage was null and void because the procedure was not solemnized. Court may say no, Qazi has given a, because that will be determined if this evidences, witnesses are, this Qazi deposed in the civil suit, let me not comment, but still if this is the deposition of the Qazi in civil suit, then it cannot be said to be a marriage.
But my lord,
Okay,
may,
that is a different aspect. We are not going whether marriage was valid, you can continue or not. You satisfy us in view of the materials available under case record. In exercise of power under 482, should we stall the investigation and quash the FIR itself? It may so happen at the time of charges, they may file wrong charges, this, that, then we can interfere. But should we? That is that you address. See, your right or his right under civil court is in totally different.
totally different.
Totally different. You are enjoying, you are possessing the land, possess it. There may be eviction, may not be eviction, this, that, this is a different issue. After going through the case diary, a prima facie materials has been collected to the extent that what is required for the actually the certificate issued according to the author is on the basis of promise of somebody else or instigation of somebody else, saying that this is the document, please issue a certificate.
No, my lord, whether he can.
Now, there are materials from one witness said that there is no marriage, only to have the property, this marriage was solemnized. There are statement of witnesses. Your own sister.
But my
Okay.
lord,
Your or whose own sister? His own sister. Your own sister. So, somebody says that this old man was looked after by A1, B, for some time by A, for some time by B, lastly by C.
well, I have been looking after him.
You are looking after.
Yes.
So therefore, at the time of, so that witness statement, we are not commenting on, so that she can have the entire property for looking after. This marriage was done, though actually there was no marriage. Is it not a criminal offense? Is it not, may not be 468, you may not have authored the document, but you may be part of the larger conspiracy.
No,
If
my lord,
468 with that conspiracy comes, then you will have to address on that.
my lord,
You will have to, I'm saying you the materials available against it.
my lord may kindly see, my lord, in the, my lord, my lord, title suit, my lord.
Mm.
On the same set of allegation, my
No,
lord.
we are saying,
Yes.
we are making it clear. There is no doubt on the fact that on prima facie reading of the FIR, except using the word fake certificate, there is no specific statement in the FIR.
Yes.
Okay?
Yes, ma'am.
What you have argued is correct.
Yes.
But can that be a ground to quash an FIR at the stage of investigation? You address us on that.
My lord, first thing.
You address us on that.
My lord, first thing, my lord.
Hmm.
My lord,
See,
I
so
was-
far relating to the judgment, which is this judgment, this is Naresh Kumar.
Yes, ma'am.
Naresh Kumar is basically a contract. Naresh Kumar is a contract.
Yes, but my lord, the next, my lord, which other one, my lord.
This is the contract. So it's a specific contract terms and condition. Now this is the case where specific that completely missing the, see, you see the language.
Which one is, lordship is,
You come to paragraph 20 of the judgment.
yes,
Paragraph 19, you read 19 and 20.
although it is true.
Hmm.
Although it is true
Hmm.
that it was not open for the court to embark upon any inquiry as to the reliability or genuineness of the allegations made in the FIR,
but at least there has to be some factual supporting material for what has been alleged in the FIR, which is completely missing in the present
So
case.
in that case, nothing was there except a statement. Here some materials have been collected.
And documentary evidence on record clearly supports that her Nikahnama was duly registered and issued by competent authority.
Now here it is a different. Her Nikahnama, according to her, was not duly done.
But my lord, may
This is,
kindly see, my lord,
is not it? So the law laid down in this judgment 468 in a pretext that except the statement, there was no material.
that is
Is
there.
it not?
My lord,
Except the statement, that is also vague, no materials were there. So therefore, in the given circumstances, in the circumstances of the said case,
my lord, that is
and see, and just read it. Law is, you'll have to go by the
yes,
ratio.
my lord, facts is at my lord page.
Now forget
Oh.
about the facts. Come to the paragraph 20. What is the ratio? In given circumstances and going to the complaint on the basis of which the FIR is registered and the other material placed on record. So we'll have to consider not only the FIR, the other materials.
Other materials on
Is that
record.
it? If we read paragraph 19 and 20, if there is no material, even in the case therein, nothing is progress, no, your statement is whatever you have stated is there, then everywhere it is said that in fact there was no marriage. So there may not be, that can be marriage, may not be what offense. Why should we interfere at this stage, quashing an FIR? So now you come to the Niharika's judgment. Said that this is a right of the investigating authority to proceed and court should not exercise its power under 482 to stall this right until and unless compelling situations exist.
My lord, may kindly appreciate one thing.
Yes.
My lord, immediately after the date, my lord, prior to the date,
See,
my lord, they have not.
Before I go to your further, another aspect of the matter is that it law is equally well settled. Suppose there is an suit for declaration that a sale deed is fraudulent. Okay? And there is a criminal case specifically saying that this sale deed was fraudulently, I was not present in my place, so and so was produced and signed. These two proceeding can proceed. No doubt about it. When it is a criminal offense, because of the matter is of a civil nature, it's not that it always should be cost. This is also a law. Yes, proceed.
My lord, may kindly appreciate one thing. My lord, immediately after the date, prior to the date, my lord, I was all along. And I am not saying that I am in relation. I am not, I am the niece. That I admitted. But my lord, subsequently, my lord, my lord, may kindly
In
see.
your statement, you say that we are in fact not husband and wife, but for the property, this was done.
No, but my lord, may kindly appreciate one thing, my lord. I was with the, my lord, doctor, and my lord, there was none to look after him. I was there. So, my lord, satisfying my service and all, my lord, my lord, by voluntarily, Dr. Ahmed, my lord, my lord, entered with marriage with me. And my lord, he also, my lord, gifted the entire property to me. And that is, I have mentioned in my.
Gifted means any gift deed?
Gift deed, my lord, oral gift deed, my lord, Muslim, my lord, Muslim
Okay.
law, my lord.
Is it necessary for Muslim to give oral gift deed to be in relation?
My lord.
Is it necessary
My lord,
that oral
what
gift
I-
can be
what-
executed only to the wife or in relation with
What?
somebody with having relation or to the relative? Is it the law?
My lord, page 77, my lord. In my lord, in reply to their, my lord, plaint, my lord. Page 77. In reply, that is, I have submitted a note, my lord. that in reply to the averments made in paragraph number 5, the answering defendant begs to state that the deceased Dr. Ahmed Hadiur Rahman got married with the answering defendant under Muslim religious rites, custom, etc., as well as by executing a deed of marriage agreement dated 5/4/2018 after living continuously in the company of the defendant for a long and uninterrupted period of about 27 years. And the said marriage was also consummated and was duly registered with the Register of Muslim Marriage and Divorce, Nalbari. A marriage certificate being so and
That
so.
is what is against in the material in the case diary.
No, my lord, what I am saying, my lord, in the case diary, my lord, what police has written, my lord,
We do not, that
I
is not,
don't know,
not
my lord.
admissible.
Because, my lord,
No,
because
no,
when
that
this
is-
court,
That is not admissible even.
yes,
But should we, on the basis after this material, can we quash a proceeding? That is the question.
my lord,
You may be correct saying this, there may not have any relevance on that, but the sum and substance of the criminal investigation comes to the light from the witnesses that there was no marriage.
I mean, even my-
Listen to me.
Yes.
This is,
yes, yes, yes.
I'm just saying what is in the case diary. That there is including you,
Yes.
your sister, okay, and your some relative below that her doctor's brother's daughter, other daughter. They say that yes, this doctor was being looked after by our cousin since long. Firstly, it was by A, then by B. Lastly, before that, this C was there. C means you. That is the assessment, and there was no marriage, nothing of that sort. But after his death, so that the property can be transferred, there are some registration and all. This is the statement of your other persons. Now, we are not saying that these are gospel truth. These are 161 statement, admissible in the cross-examination that may be demolished. There may not be any charge sheet also. Police may give final report. Number two, you yourself says that, okay, whatever you have said in the paragraph 20 of your written statement is absolutely opposite in what is your statement recorded
Yes,
under
yes,
161.
Yes.
Okay. Third is that upon whom you are relying on issuance of certificate, his statement is that there is no solemnization of marriage as per Muslim custom. Only somebody, one of lawyer who is my known person, he says there is an agreement. Therefore, on the basis of that said, and I have said him that don't use it as a marriage because you have given me the, so that
So,
is.
my lord may kindly appreciate the thing. My lord, whether a register, my, can we expect, my lord, his statement can be true, my
We
lord?
do not know.
No,
We are
because,
in
my lord,
482.
My lord,
We do
when-
not know that. See, if we say that his statements are wrong, then 161 other statements are wrong, then we'll have to do the trial here on the basis of believable and not believable, relying on believable and not believable.
that is, on that.
So we'll have to make a determination that his story is not reliable. However, her statement is reliable. This statement is not reliable. Therefore, no case is made out.
My lord, here,
Your
my lord,
whole case in a quashing procedure still holds the determination made in Bhajanlal.
Yes.
Whatsoever way.
Yes, Bhajanlal,
Abuse
my lord, I am
and
relying
no
on-
case is made out. In your case, abuse and no case is made out.
Yes.
Now, so far relating to the no case is made out, no case is made out only on the reading. Okay. But a fact has come out that actually there was no marriage and marriage was for the property. This is the initial investigation. Okay, so let the investigation proceed.
My lord, on the same context, my lord, on the same context, my lord, why they have come up with this, my lord, criminal proceeding, my lord? Because, my lord, as per their contention is that the marriage certificate is a forged one, and, my lord, the circle officer ought not to have grant, my lord, mutation. So, my lord, on that two aspects, my lord, separate proceedings is already pending, my lord, before the competent court, my lord. So, my lord, if that court decides in their favor, then the matter ends, my lord. So, my lord, where is the, my lord, scope of proceeding of this, my lord, criminal proceeding, my lord? And one more aspect, my lord, may kindly see, my lord, the status of the, my lord, the informant, my lord, complainant, my lord. Because, my lord, my lord, first, my lord, immediately after that, they have come to, my lord, oust me from that property so that they can capture that property, my lord. Their intention is that, my lord. So, my lord, they, my lord, applied for a death certificate. Immediately, my lord, death certificate was they have procured. Thereafter, within 11 days, my lord. Thereafter, my lord, they have procured the next of kin certificate, my lord. Where next of in the next kin certificate, my name was withheld, and as many as 11, 12 numbers of legal heirs have been, my lord, entered, my lord. But subsequently, my lord, my lord, a committee, my lord, the revenue authority, my lord, revert back the, my lord, no objection certificate, my lord, of next of kin certificate, my lord. So, my lord, their, my lord, status, my lord, as a legal heir, that remains doubtful, my lord.
We'll have to say here it in the 482. Ignoring what have been stated in the investigation.
And, my lord, this court, my lord, when notice was issued, my lord, police was directed to not to take any coercive action, my lord. But, my lord, thereafter, my lord, I have been asked, my lord, to come, my lord, at any time, my lord. So, my lord, it's all, my lord, this completely motivated by the.
No, you argue to the point that on the basis of these materials, that what I have explained, that's why I have given you the hint. What are the statements? An FIR read with the proceeding can be quashed in terms of these two judgments you have relied on.
Yes, my lord.
You argue that. Yes, Abdullah, what are the offenses made out?
Lordship, it is a matter of investigation, but my lord, the documents which have been, if she would not have been applied.
Just answer. Nobody is answering what actually is the matter is.
Yes, Lordship.
Arguing emotional arguments, I am lonely lady, they will grab my property. These are having no value in the courts in a 482.
My lord, what
That
will
police
be
is harassing me, that cannot be a ground of quashing.
here, my lord, admittedly, my lord, forgery.
These can you
criminal
file a
breach
suit
of
for
trust.
injunction? Property is mutated in your name, you say orally, file a suit, file a counterclaim for injunction.
My lord,
If your
already, my lord, that has been.
police is harassing, file a 226. Can that be ground for quashing? Yes, what are the cases?
Possible a case under
If we take the
471 of-
FIR, if we take the FIR to be correct,
Lordship.
this is the principle of law. And if we take the statements of the witnesses collected till now, there cannot be a further, this is the Qazi is examined, the accused is examined, then some of the relatives examined, and whatever their statements I have already disclosed. Now tell us what are the offenses?
My lord, possibly 471, my lord.
Why?
My lord, using as genuine a forged document.
471.
Or electronic record, my lord.
Do you say this is a forgery? They say no, document is ID, I am the author. This certificate was issued by me.
Lordship. But my lord, it is a
That's why I'm asking, what is the criminal offense?
It is a matter of conspiracy, my lord, Lordship. Lordship may
Conspiracy to do what? There must be a principal offense.
Lordship, conspiracy by
To do
using a
what?
false document,
Conspiracy
to
There is no forgery from the material. Now what are the offenses? He is also not arguing that. We are not here to listen to your emotional arguments. No substance in your argument. Even I have told you what are the materials collected. Tell us what are the criminal offenses from the materials collected. See, I am repeating. I am repeating. The accused, the Qazi says that yes, this certificate I have issued. Okay. I have issued. However, no formal thing was done, but I have issued on the basis of a agreement of marriage, notarized agreement of marriage between A and B. Okay. So offense, what is the offense? That may lead to the marriage to be invalid. Because the procedure is, listen to me. Procedure is wrong. So that can be a ground for that cannot be a valid document. There is a distinction between a valid document and a forged document. So if it is not a forged document, then when 4671 will come? So it is an absolutely civil dispute that this was declaration. Therefore, they are seeking the declaration. You are seeking the declaration that you are that this marriage is void, because when it will be void, when the required process under the Mohammedan law is not followed and certificate is issued in different way. Where is the offense? Sum and substance is this is the case.
But the procedure,
Tell us what is the criminal offense. I'm saying this. This is the facts. Admitted fact. So on the basis of the law is well settled. On the basis of even admitted document, we can question proceeding. You take your seat. No substance, young lawyers, you are arguing cases. What is the, I'm saying that all these are correct. 160 statements are correct. FIR is correct. What is the offense made out?
To me, my lord, that notarized marriage certificate is also forged, my lord. Because that is a forged document, but they have made it.
Don't say it is a forged document. The author says it is not forged. I have issued the certificate.
No.
I am Qazi. I am issued
the basis of what the notarized certificate.
He has issued the certificate on the basis of without following due process.
Due process.
Due process.
On the basis of
By due process. So tell us what is then offense then. This is not a forgery. What is the offense? Criminal offense. That may lead the marriage to be void or voidable. But what is the criminal offense? Day after tomorrow. Come prepared.
Not the day after tomorrow. That whether this marriage is okay.
And will not give you any hearing next day. This is the whole issue. That if materials are there, that's why I was repeating that these are the materials. There can be no more materials because the person who issued, admittedly who issued the certificate alleged by you and accepted by him, has said that yes, I have issued, but I have issued not following, not performing the marriage, but will it make a document forced? This will be an invalid document. At best.
A person from Kitab or my lord went to Nalbari.
Again, you are saying a story. We are not here to listen to your stories. We are here to listen to substantive argument.
Okay, on legal point, I'll try.
That on next day, immediately they have taken neck to kin certificate that somebody has come from Golaghat to Nalbari. So can that be a ground to quash or not to quash?
Next day, my lord, day after tomorrow.
I mean, almost 40 minutes we have spent. And this is the situation of Guwahati High Court as regards young councils. You will come stereotypes and no answer to the questions. And you are the future of Guwahati High Court. Sorry to say. I could have dictated this order long back. I expected all arguments from you. Please this matter tomorrow for further hearing. Gogoi, you also enlighten us. This is the material. What is the criminal offense? Show us if you can show us, because we may not know what is the criminal offense. If you can show us that for this, these are the criminal offense, therefore it should be allowed to proceed. Otherwise, we will not allow to.
My lord, day after tomorrow.
We'll take it up tomorrow. Great. Or কিমানটা আছে? Admission. Very nice. Give me the on last. কালি যেটা ফিক্স করছিল একটু ফাইল তাতে ভরাই দিও। কালি এটা ফিক্স করছিল বল না? Yes, Mr. Chaudhary.
May I please your worship?
Yes.
My lord, in this criminal petition, my lord, we have challenged the order dated, my lord, 4/3/2023.
4/3.
Order
Where do we get that?
4/3/2023.
Page.
Page, my lord, 44, my lord.
Hello. Material লাগিলে পিছ ফালে ভিতরে। Oh. Page.
Page, my lord, 44,
44.
Annex 3.
Okay. Okay.
Then, my lord, lordship will come to the next page, 45, my lord.
I have seen that.
That is, my lord, charge with head, my lord. Here, my lord, learned quote below, my lord. It is not sure, my lord, whether I have committed the crime or not. The model charge is like that, my lord, that on so and such date, you have commit murder. But learned quote below is not sure, my lord, because it will be proved during the trial, my lord. Charge should have been, my lord, that on so and so that you have committed murder. Or with your common intention, my lord.
He said that you inflicted injury and result of which he died after a month.
About 1 month due to septicemia. And you would be responsible for causing death of the deceased if the above facts are proved. Model charge, my lord, from Ratanlal Dhiraj, I have found, my lord, that it should be that on so and so date.
Specific.
Yes.
Such should be clear, not ambiguous. There should not be any ambiguity. That you have done such and such on such and such date. Details will follow in the trial.
Yes, that is missing, my lord. And my lord, in this case, my lord, this three petitioners, my lord, they were students of my lord Assam University.
There are 3 petitioners here.
In this, my lord, 3 petitioners are there. Here was a, my lord, group class. As per the, my lord, the statement of the, my lord, the victim, my lord. He is the informant of the case. My lord, that occurrence had taken place on, my lord, 17/8/2011, my lord.
Okay. Where do you get the affair?
My lord. Lordship will find the FIR at page 30, my lord.
30.
30. These are format, my lord. Lordship will come to, my lord, 31, my lord.
Just a minute. All these 439 applications, we cannot wait.
My lord. May I read it, my lord?
Yes.
The humble submission, Ratnadeep Malakar, he is the, my lord, victim. Subsequently, he died after a month. So he lost the affair, my lord, on 18, my lord. 17/11 is the, my lord, 17/8 is the, my lord, date of occurrence around 3 p.m., my lord. And on the, my lord, next day, my lord, he has lost the affair. So in this affair, my lord, he has stated that, my lord, at about 3 p.m., 17/8/2011, I, the informant, after appearing the examination of the said university, came out. And as soon as I arrived in front of the gate of the university, a few students of IT department of the university came and asked me to which department I belong. Then I told that I am studying in SW department. The said agitated students assaulted me with rod, branches of tree, iron chain, and belt, causing serious injuries on my right eye and various parts of my body. The said students also snatched away cash amount of rupees 2340, which is in the purse in the pocket of my pant. Out of the said students, the name of one is Omit Misra of IT department, and the others I could recognize if I see them. This is the, my lord, contents of the, my lord, affair. So, my lord, in the affair, my lord, he has named one Amit Misra, my lord. So, my lord, on 17/8/2011 itself, my lord, he was taken to, my lord, Silchar Medical College Hospital, my lord. And there, my lord, he was examined. And that injury report I have annexed, my lord, as Annexer 8 at page 99.
Page 99.
99, my lord.
Just a minute.
My lord.
Why injury report? When was he examined?
He was taken on, my lord, 17/8/2011, my lord. Same day, around 8 p.m., my lord, he was in the.
Why report is 16/9?
Which one, my lord?
That page 9, page 102. You are saying about the page 102 or 9? Huh?
Date and time of entry, my lord, 17/8/2011.
Where do you get that?
Very beginning, my lord. Number
Page
one.
102.
99, my lord.
Okay, 99. Just a minute. Yes, 99.
Date and time of entry, my lord, 17/8/11 at 8 p.m.
Yes.
So, my lord, on his examination, my lord, only there was an injury in the right eyelid, my lord. That swollen cartoon 1 by 1 centimeter over lateral canthus, 1 into 1 centimeter below medial canthus. Then, my lord, left abrasion over infraorbital margin. So, this was the injuries, my lord, he received when he was first admitted for, my lord, for treating him in the hospital, my lord, Silchar Medical College Hospital. So, my lord, on that day, my lord, after his this examination, he was released. He has come back to his, my lord, one of his aunt's place, who is Sebika Malakar, man.
Now, what is page 1? The postmortem. Okay, okay.
My
Then-
lord,
then what-
postmortem I am coming.
Then
to.
what happened?
Yes, my lord.
On 7/18, he was
17/8/2011, he was treated in the, my lord, Silchar Medical College Hospital. He was released that night, my lord. He came back to the house of his aunt. He stayed there in the house, my lord, in the aunt's house. Next day morning, my lord, his father came, my lord. From Karimganj to Silchar, he came, my lord. Then next day, they went to the police station, my lord. Thereafter, my lord, again they went to the, my lord, hospital. There also, as senior doctors were not there, so no treatment could be given him on that day. So on my lord, 19/8/11, my lord, after examining by the doctors at my lord Silchar Medical College Hospital, it was advised that he should go to my lord Netralaya.
On 1911.
19/8/11.
Yes, then
Then my lord,
where do you get all this?
uh,
From statements.
from his statement also
Okay,
we'll find
we'll
my
see
lord,
it
we'll
later.
find that.
Ah.
Then my lord, after my lord, on 21st, I think he came back, my lord, he went to Karimganj. Then my lord, from Karimganj with his father, my lord, he came to Netralaya, my lord. And in Netralaya, my lord, as a outdoor patient, my lord, he took the treatment, my lord. So subsequently on 30/8/2011, my lord, he was released from Netralaya, my lord. Then he went back home, my lord. Then, my lord, during all days, he was fine, my lord. There was no such, my lord, complication or anything. And my lord, during this time, no one has informed the doctor, my lord, sorry, investigating officer, that he was treated by, assaulted by these petitioners. My lord. What is there in the statement of my lord, these witnesses, my lord? One of the witnesses is, he is his aunt, my lord, Sebika Malakar. What is stated, my lord? That on 19/8/2011, my lord, when after coming from Silchar Medical College, my lord, he told this aunt that he handed over one piece of paper where the name of this petitioner and another person's name was written. Only name, nothing else.
Okay.
And 17th, his statement was recorded by police, my lord. 18th, his statement was recorded. Nowhere, my lord, he has stated these names, my lord.
His statements were recorded on when?
Recorded on 17/8/11 before,
On the date itself.
on the date of occurrence before lodging the affair.
Mm.
And again on my lord, 18/8/2011, after my lord, his affair was lost.
Okay. Yes, he has not stated.
He has not stated on these 2 days, my lord.
Okay, then
Then, my lord, after getting treatment, preliminary treatment or whatever it is,
when
my
this lady was examined as witness
lady, my lord,
by unrecorded,
one statement I have
What-
got on my lord, 5/7.
161 statement was recorded when? This ladies once or twice or
I have annexed only one statement, my lord, because I received only one statement.
okay, when
That is 5/7/2013. 5/7/2013. Before, my lord, this charge sheet was submitted.
is okay. Okay, we'll go to this. Okay, till 5/7/2013. When he died,
He died on, my lord, 15/9/2011.
9
Almost a month, 28 or 29 days.
29 days.
15.
9
9/2011.
Okay. Then 15/9 he died.
Right.
What was the cause of death?
Lordship will come to the, my lord, the post-mortem, my lord, report. I have annexed, my lord.
102.
102 it starts, my lord. Here, my lord, in this post-mortem report, doctor, my lord, post-mortem doctor, my lord, he has not found any injuries, my lord. Even the eye injuries also, my lord, that was not there on, my lord, after a month, my lord.
What is the cause of death?
Cause of the death, my lord, last page 104. In my opinion, last, my lord, last, has your lordship got it, my lord?
Yes.
Last line, my lord. In my opinion, death is due to cardiorespiratory failure following septicemia.
No internal injury.
No internal injury, no external injury as per the postmortem report.
Yes.
So, my lord. What?
Yes, you want to say something?
Just one thing like to clarify, madam. There are injuries, madam, that has in the medical report at the time of his admission, madam, that he was medically examined. Then, madam, certain injuries are found. Madam.
No, that we have seen
Yes, that.
from on 17/8
Seven.
that eye injury
Yes,
and
yes, yes.
different injuries.
But that, madam,
Ah.
then it happened, madam. Was referred to the
Natural eye.
Natural eye surgeon after that on that basis. And
He had a fever with complaint of rashes.
This happened, my lord, because of the septicemia, these things happens, my lord. Whatever, my lord, perhaps.
Sepsis, that's why I've asked whether any internal injury.
From the, my lord.
Because sepsis can be infection internal from internal injury. Also.
Yes, yes, that might happen, my lord.
Yes, yes, anyway.
My lord, from the, this postmortem report, my lord, we neither find, my lord, any internal injuries or external injuries. But the cause of the death is, my lord,
Septicemia.
it is respiratory failure, cardiorespiratory failure due to septicemia, my lord.
Multi-organ failure. Yes.
And my lord, in this period of month, my lord, he was neither hospitalized, my lord. So, my lord, if sometimes, my lord, some patient stays in the hospital because of, my lord, this prolonged stay in the hospital, my lord, this septicemia occurs.
Yes, yes.
So, my lord, this is the postmortem report of the, my lord, deceased, my lord.
Now, on whose evidence or 161 statement 302 is brought in?
My lord.
That is because one is that then we'll go to the standard what kind of material that we should consider for discharge or under this is under 227 is that
227 and 228.
228.
Yes.
Then we'll come to what extent we can go into. First, we'll understand what are the materials. Then we'll go to the legal principle. Yes.
My lord, if we go to the statement of the, my lord, this victim, my lord, this Rinku Malakar, Ratnadip Malakar, my lord.
So you want to say, except that communication and statement of the aunt, there is nothing to suggest. Even forget about others, the role of this petition.
Yes, that is my submission.
Not to say that whether they have frame or not 302 or not, but no search can even be framed. This is your case. Forget about 302. No search can be framed. Okay, so let us see the. So what is the standard? It should be, we'll have to accept everything to be correct.
Yes, yes, ma'am.
We'll
whatever is there,
there
in this
is to
statement.
be correct.
Yes.
Then whether
those materials are, my lord, sufficient to frame charge either under section 302 or in any other section, my lord.
Yes.
My lord, first, my lord, coming to the statement of the, my lord, boy, my lord,
Where is that?
Ratnadip Malakar.
Page.
His statement, my lord, was recorded on 17/8/2011 at page 51, my lord.
Page 51.
Annexes.
Ahmed and yeah, Goswami. So you don't have any problem with the translation?
And there, my lord.
Or we'll go
regarding
to the vernacular.
Vernacular, we cannot, my lord, because I have seen the LCR part, my lord. It's illegible and also in Bengali medium, my lord. that will. have-
Bengali, I have no problem.
Yes, and also illegible, my lord. That's, I've tried to read some of the statements, my lord.
Okay, so we'll go by the translation.
Because
Well, if necessary, my lord, I can read in the Bengali also.
No, I can also, I understand also. I can read, understand, I have no problem.
and here I could not read all the statements.
You just, here you can read it. Bengali, you read it. Let us have no confusion.
Yes.
Ultimately, English is a foreign language. Yes.
Here, my lord, only I am on, my lord, the, how many participants were there, my lord, as per him, my lord. Here he has spoken about, my lord, the time of occurrence on 17/8/2011. Then, my lord, that after finishing examination, my lord, he reached the main gate. Here, my lord, he has stated, অনুমান 3টার সময় পরীক্ষা
Page,
my lord,
54.
52 is the vernacular, my lord.
Okay, 52. Okay.
Fourth line, my lord, fourth line. 17/8/2001 ইংরাজি বিকাল অনুমান 3টার সময় পরীক্ষা শেষ করিয়া আমি পাশে মেইন গেটের বাইরে হঠাৎ করে 30-40 জন আইটি বিভাগের ছাত্রর দল আসিয়া আমারে জিজ্ঞাসা করে যে তুমি কোন ডিপার্টমেন্ট, তখন আমি SW ডিপার্টমেন্ট বলা মাত্র ওই আইটি বিভাগের ছাত্ররা উত্তেজিত হয়ে হাতে রড চেইন নিয়ে আমাকে
আমাকে ও রাস্তার পাশে থাকা
মারপিট করে।
হ্যাঁ।
আর তখন পাশে রাস্তার পাশে থাকা হাজামের দোকানের কাছে ভিতরে লুকায়া থাকি।
So
তখন
whether Hazam was examined?
Hazam was, I think, examined, my lord.
Huh?
Hazam, I
Just
think.
note it down. Hazam was examined.
Yes. হুজুর শাসন পাতে
লুকায় থাকি তখন ও ছাত্ররা জাপ ভাঙিয়া আমারে ভিতর থেকে উলিয়া বাহির করিয়া মারপিট করে
আনিয়া করে মারপিট করিয়া জখম করে। আর আমাকে মেডিকেল আনার পর জানিতে পারি যে দেবাশিস দাস ও এলিয়াস বিশ্বনাথ দে, মৃদুল শুক্লবৈদ্য ও জখম প্রাপ্ত
হয়
তাহারাও SMH এ আনিয়াছেন। আরো অতদের 30-40 জন ছাত্রের মধ্যে একজনকে চিনিতে পারি, তার নাম অমিত মিশ্র, আইটি ডিপার্টমেন্ট। বাকিগণকে দেখিলে চিনিতে পারিব। বর্তমানে আমার স্বাস্থ্য ভালো না থাকার
কিছু বলিতে পারছি না।
So this is his first statement. So on his statement, my lord, he has stated that there are about 30 to 40 students in the group, my
He
lord.
could identify Omit.
And these 30 to 40 students, my lord, they had assaulted.
Hazam's statement
Hazam.
is there, Lordship, page
Hazam.
72. Huh? Page 7. Just note it.
72.
Now is again his second statement.
Second statement also,
54.
my lord, he has stated almost the same thing what he has stated earlier, my lord. Here also he has stated about that he hid, my lord, in the barber shop. Then that, my lord, students had taken out of the salon, my lord, by breaking the planks of the salon and assaulted him, snatching away of rupees that 2340, my lord. Then I know Amit Mishra very well. I do not know the names of the other students. I will be able to recognize them if I see them. Here, my lord, I have wrongly translated, my lord. This should be I was treated. I written as, my lord, translated and admitted. Lordship would kindly look at that, my lord.
আমি অমিত মিশ্রকে ভালোভাবে চিনি ও বাকি ছাত্রদের নাম জানা নাই।
দেখিলে চিনিতে
চিনতে পারিব।
আমাকে জখমি অবস্থায় গতকালে মেডিকেলে আনিয়ে চিকিৎসা করানো হয়েছে আর বর্তমানে আমার শারীরিক অবস্থা ভালো নয় তাই অদ্য ইউনিভার্সিটিকে যায়া ঘটনাস্থলে দেখানো আমার সম্ভব নয় আমি আমার আমার বাবা সাথে বাড়ি
যাইতেছি
that is on my lord next day on 18/8 my lord আমি কিছু সুস্থ হওয়ার পর আসিয়া আমি আপনাকে
Thereafter, his statement was never taken till the next one. Anyway.
till his death my lord there was no statement taken.
Okay. Then
Then my lord his father's statement.
fifth,
Father's statement was recorded thrice my lord on 18/8/2011 at page 55.
18/8, then
2011
55,
at
then
page 55 my lord.
then
Then on 16/9/2011
and then
at page 57, that is after the death of his son my lord.
two and then thereafter.
Thereafter my lord on at page 59 my lord. That was recorded my lord on 5/7/2013.
16/9 is
After the death of his son. my lord.
16/9/11.
11.
Okay, let us see what is this.
Here also, my lord, on page 55, my lord. Same thing he has stated that, my lord, his son stated about the name of Amit Mishra only. Then, my lord, after listening to this, I immediately took my son to Silchar Sadar PS and my son lost the written FIR, my lord. So on 18/8/2011, my lord, his son lost the FIR. It is to be mentioned that now I will again take my son to the medical for further examination, and therefore it is not possible to send him with you to the university now. After my son gets a little better by taking him to you and show you to the place of occurrence. This is my statement. So, my lord, at page 57, my lord, which is taken on my lord 16/9/2011, my lord. Here also, my lord, he has stated that, my lord, his son could identify only Amit Mishra. Then, my lord, he stated that it is to be mentioned herein that from the date of occurrence to 19/8/2011, my son was admitted in SMCH and referred to Shankar Dev Netralaya, Guwahati. And from 23/8/2011 to 30/8/2011, my son was given treatment in Shankar Dev Netralaya. Therefore, as per doctor advice, my son was taken to Karimganj Government Hospital on 12th September, and for better treatment, doctor referred him to SMCH. That on the way to SMS, my son's cells deteriorated. This is subsequently, my lord. When he was at home, my lord, one day he, my lord, got his severe pain on his stomach, my lord. Then he was taken there, my lord. He was taken to Red Cross Hospital, my lord. Then on the afternoon, he was, my lord, released by the doctor. And I took my son Ratnadeep to our house. Then on, my lord, 15/9/11, my lord, he died.
Any materials regarding his examination during this period in the case diary? 15th to 14th? No.
But Lordship may kindly say page 75.
No, will come. Now, what is 59? That is third statement.
Third statement, my lord. That is almost, my lord, after 2 years. 5/7/2013.
Yes.
Here, my lord, he has stated about my lord treatment taken at my lord Shankar Netralaya, my lord. Yes, mostly spoken about, my lord, the treatment what had been given, my lord.
Mr. Chaudhary Junior, have a list of dates from this evidence. What he has stated from him only, no addition, no deletion.
Okay, got it.
Who are the petitioners here?
My lord,
Ashish.
Sosi Kumar Dr. My lord, petitioner number 1.
Hmm.
Then my lord, Rabi Yadav, my lord.
Hmm.
And number 3 in my lord, Himang Sharma.
What about Ashish Panda?
He has not approached, my lord. Ashish Panda, my lord.
You are sent for.
He was shown as absconder, my lord.
Okay. Okay, now let us go to the
So
same.
lordship has, my lord, here, my lord, after all this, my lord, is regarding his, my lord, treatment. what my lord treatment provided till his death, my lord. And my lord, at page 62, as your lordship got it, my lord, that on 15/9/2011, my sister, that means my lord, his father's sister, my lord, aunt, Sebika Malakar, and my brother-in-law Uttam Malakar came to our house.
I have
in-
marked it.
Your lordship has marked it, my
Marked
lord.
it.
That is my lord.
Then the MLA came, then
Yes,
his
yes.
Caesar and all.
Yes, my lord.
And according to her, he said that don't tell, my father will go here and there.
Here and there,
My
he will not give me
treatment
proper
will
treatment, my
be
treatment will
delayed.
get delayed and all,
Okay.
my lord.
Now
Those
let us
things.
see what is the Sebika statement.
My lord, lordship will come to Sebika Malakkar's statement, my lord. That lordship will find at page 94.
94. Ninety-four.
Yes, my lord. He stated that, my lord, around 17/8/2011 at around 9 p.m.
Mhm.
My elder brother Rinku Malakkar's son Ratnadeep Malakkar came to our house in injured condition with some friends. On being questioned about his injuries, he said that some boys of the some university had assaulted him in front of the university gate, and that he went to Silchar Medical College for treatment after coming from hospital, man. Then we asked him to stay in our house, saying that necessary action will have to be taken when his father Rinku Malakkar comes the next day. The next day, that is on 18/8/2011, his father Rinku Malakkar came and took his injured son Ratnadeep Malakkar to Silchar Sadar Police Station. After lodging a written ezahar about the incident in Silchar Police Station, Ratnadeep Malakkar and his friend and his father Rinku Malakkar again came back to our house at around 4.
Her statement was recorded for the first time on, this is the first time after his death.
Yes. That is 5/7. My lord, there may be one statement, my lord, which because in my, my lord, whatever copies were supplied to us, my lord, there I have got only this statement.
Yes, look into whether, because she was a vital witness at that point of time also, before its declaration. She was taken to her place, she stayed there. Whether she was examined prior to this.
See, man, all the witnesses that were cited in the charge sheet, all the statements are not there. And Sevika's statements there, madam. Are there. One statement we have, it I have not seen, man. Tagmar's man there. LCR part.
Okay, LCR is here. You just
LCR here.
see. Just I want to see that these persons were examined later on. This Sebika or earlier also. As such, the like the father was examined twice. He was examined twice because time it was necessity.
Yes.
So now is any statement of Sebika earlier to this
Before her death.
before his death
This statement was recorded, my lord, prior to submission of the charge sheet on 5/7/2013.
because this twist has come after his death. This twist has come in after. This is they might argue this is a new fact discovered. He was not examined. Till then, okay. Anyway, we'll see it then. Yes. Then
My lord, we asked him to stay in our house, saying that necessary have to be taken by when his father comes. Next day, 18/8/11, his father Rinku Malakkar came and took his injured son to Silchar Sadar Police Station. After lodging a written ezahar about the incident in Silchar Police Station, Ratnadeep Malakkar and his father again came back to our house at around 4:30 p.m. and informed that Ratnadeep was taken to Silchar Medical College for treatment and examination with the help of police, but due to unavailability of senior doctors, they will have to go to Silchar Medical College again the next day. And so we asked them to stay in our house. The next day, on 19/8/2011, my brother Rinku Malakkar, along with his injured son Ratnadeep Malakkar, again went to Silchar Medical College with police, and both father and son returned around 3 p.m. and informed that Ratnadeep's right eye had severe injuries
and therefore he was referred to Sankardev Netralaya, Guwahati. Since they had not much money with them, that evening at around 9 p.m., both father and son went to their house at Karimganj in order to manage some money. At the time of going, my nephew Rinku Malakar gave in my hand a sheet of paper where 4 persons' names were written and said, "Hunt, keep this paper where these names are written. Do not give it to my father. If my father finds it, he will take this and keep running hither and thither to the police, and my eye treatment will get delayed. When I get well, I will come and give the names of the police myself. I have written the names on remembering they are involved in assaulting me." Said and gave the sheet in my hand. So, my lord, this sheet of paper, my lord, where the names of these 4 students, these petitioners, my lord, were written, that was given on 19/8/2011. In the piece of paper, my lord, only the names were there. And my lord, this aunt told that, my lord, they were also, my lord, involved in, I have written the names on remembering, they are involved in assaulting me.
So her story is this, that he gave it to me and said that after recalling, remembering it, I note it down. Keep it, I will give it after my treatment, I'll give it to police,
Yes.
don't disclose it to anyone.
Yes.
So accordingly, the aunt kept silent
silent.
and she could not stop her cries when she saw her nephew dead body.
Dead
And
body.
since she disclosed.
Yes, yes.
So basically, what are the materials? Materials are the documents, what the forensic says.
Forensics result, my lord, here not annexed with that.
Yes, anything on forensic report. Then how search sheet was done?
Statement. But there are some statements which says, my lord, the copy was.
See, next stage will be to understand, will be the report, what it says.
First thing, because I was not searching for that, my lord.
Hmm.
Some I have found, my lord, where it is stated for FSL, the police has seized those documents from us. Then it was for
That
sending-
has been seized, and
for
because
sending to
story's statement is this, initially the MLA came into the house, then MLA said, okay, you see this, if this is the situation, give a copy to the police. Then they gave a Xerox copy. It went to it went for forensic, then forensic returned it, saying that Xerox will not do. Then thereafter formal seizure of the original was done.
Correct.
Then what happened thereafter? No, not ascertained. There is no question of ascertaining now. Whether it was seized and FSL report is a part of this, any copy is given to.
Page 43, Lordship may kindly see that it is mentioned about FSL report is submitted along with the charge sheet.
Where is
Page
that?
43.
Charge sheet, lordship will find.
It is there.
Yes, yes.
FSL or
A copy be given to you, sir, FSL.
That FSL or report ইত্যাদি গাঁথি দিয়া হল।
Gathidia hole, we can
It
understand,
is submitted in
but
the
why
report of
not
court.
copy is been given
What
to
is
him?
positive report or negative report, that should be, my lord, known to
And
the
why
accuser.
copy is not given to him?
also not a part of.
Elsewhere, it is not a part, it's not a part of the case diary. So that is one of the important issue.
I will address.
Huh?
I will
Or you
address.
say that for discharge FSL report is need not.
No, other eyewitnesses are there, injured eyewitnesses are there. I will place before your lordship.
I injured
Yes,
eyewitness
injured
naming
eyewitness.
this
Yes,
person.
They said lordship, they can identify them lordship.
When?
That part is.
Anyway, this is one part of the story. So basically, this is according to Mr. Chaudhuri, there is no prima facie material to bring me into commission of the offense. The eyewitness has not named me.
Victim, injured victim.
Injured victim. The injured victim, who is the eyewitness, has not named me. Okay, and thereafter, my name came in after his death.
When Sevika handed
When,
over,
when Sebika handed over. And there is nothing to show, forensic is not there to even implicate me. Anyway, this is your argument.
my,
Now, what will be your legal points here?
my lord, I should point out another thing, my lord.
Yes.
Yes, my lord, the 31/10/2011, my lord. First that, my lord, photostat copy were given.
Hmm.
Lordship will find at page 47 and Annexure 5.
Page 47. Hmm. That is there.
Then, my lord, on 23, 2000 at page 49, my lord.
Page 49.
49.
Hmm. This is original.
This is original was says,
Hmm.
my lord.
Okay. So what will be your argument in these given facts?
Oh, my lord, first thing is that, my lord, the date, how date has caused, my lord.
Yes.
From whatever, my lord, the statement has been recorded, as there is no eyewitness to the occurrence. Eyewitness was there, but he died, my lord. That is victim. And there are, my lord, some injured witnesses, as my friend has pointed out, my lord. They have also stated the same thing, name of Amit Misra, my lord, and that they could identify when, my lord, they could see, my lord. But, my lord, because, my lord, in this case, whatever, my lord, materials has come, my lord, in this, till the filing of the search sheet, my lord. Except that, my lord, that piece of paper, my lord, where only the names of the, my lord, these three, my lord, petitioners, along with another is, my lord, their names are written. Besides that, my lord, nothing has been stated. My lord. That in that, my lord, the victim has written the names and stated that these boys has, my lord, assaulted me. That part is also not there. Only the names are there. And what Aunt has stated, my lord, Aunt has stated that a piece of paper has been given where these names are there. And he stated that, my lord, they have
He has
also,
recalled his name.
yes.
So
So, my
therefore,
lord-
according to you, even if it is stated to be correct,
Yes. Even, my
even
lord,
if it is stated to be correct that he has written it, given the name on the basis of this piece of paper,
yes.
we cannot be.
Whether, my lord, the frame of charge under section 302/34, my lord, could be framed, my lord. In what manner, my lord, we have assaulted? Nothing is there, my lord. What injuries we have caused, my lord? Nothing has been mentioned, my lord. And from, my lord, the injury report, my lord, which was very day he was examined. On the, my lord, date of occurrence, he was examined. Except the, my lord, the injuries on the eye, my lord.
No internal injury.
Doctor did not find any internal or external injury on that day, my lord. And then, my lord, after about a month, my lord, after his death, my lord, this post-mortem examination was done, my lord. There also, we do not find any, my lord, internal injuries, external injuries, or even the injuries of the eye also has not been mentioned in the post-mortem report, my lord. So for homicidal death, my lord, causing death man by man, my lord, of which injuries, my lord, he has died, and because of which injuries, my lord, that septicemia has occurred, my lord.
Yes.
To die of septicemia, my lord, there has to be some either internal injuries or external injuries, my lord. But in the post-mortem report, my lord, we do not find anything, my lord. In that case, my lord, whether a charge a serious offense like, my lord, murder, my lord, that could be framed against these accused persons, my lord. And mostly, my lord, the first search sheet was submitted not under section 302, my lord.
First
Search
search
sheet submitted under section, my lord, 325.
see
If-
when?
If I am not wrong, my lord. 323 to 325. At page 41, my lord.
Then when the subsequent was filed? After date?
Which one, my lord?
That final 302.
302 from by the, my lord, magistrate. When he received my lord, my search sheet, my lord,
was not.
at the time of taking cognizance.
Okay, at the time of hearing.
So that is why, my lord, this case was committed to the, my lord, Court of Sessions, my lord.
Okay.
And as I pointed out, my lord, the charge of hate is also my humble submission before your lordship,
Yeah.
that is defective, my lord.
Yes.
That Hazam's statement also, my lord, lordship will find, my lord, he also stated about Mishra only, my lord,
Where is that?
at page, my lord, 71. Last four lines, my lord, at page 71. Last four lines, my lord. Yeah, I do not. Has your lordship got it, my lord? He also spoken about only, my lord, omit, my lord.
Yes. And who are the other witnesses injured other statements that you want to rely? Page?
One is Devashish Das at page 75, my lord. Here also last four lines, my lord. He also stated that about 30-40 students of the IT department who were carrying rod, chain, belt, started some chaos and marpit where I was injured. And this I was, and thus I was taken to Silchar Medical College and also Ratnadeep Malakar, Mridul Shuklapodya and Vishwanath Roy.
Yes.
Here also, my lord, he speaks about, my lord, omit only, my lord. Speaks about only omit, my lord.
Yes.
So, my lord, to frame charge under section, my lord, 302, there has to be, my lord, some overtact, either direct or indirect, my lord. So those things are missing in this, my lord, the statement of the witnesses, my lord. And from the post-mortem report as well as the injury report, my lord, nothing could be attributed, my lord, that these three petitioners, my lord, they have, my lord, assaulted in any manner.
My lord, some Perhaps the FSL. But absolutely, my lord, not.
Okay, we'll get it. We'll get it. Since we have spent so much of time, we'll have satisfaction from all spare. Just flag mark it. Yes.
So my lord, this is my lord submission.
Any
And my lord, I have, yeah,
Section.
and regarding my lord law point, I have found out a number of decisions, my lord. Where my lord.
Okay.
In the list, my lord, I have, my lord, given the my lord paragraphs, my lord, where it has been relied on, my lord.
Okay, we'll see. We'll hear another day because we need to go through the SLP. We'll go through it. These are the you are relying on?
Yes.
Yes, PP.
Shahzad Pul. Did get out like that one. Yeah, plus I.
Facts more or less and
Yes, madam,
statements
clear.
we are clear. He has
Clear.
already read it. This is clear.
Now, my lord, the fact is that now we are in the stage of, what is the stage? We are in the stage of consideration of charge, my lord. So prima facie, my lord, we have to, my lord, I am just pointing out that, my lord, the court has to satisfy whether.
We will not, we cannot make a mini trial here.
Mini trial. That is
We are
what-
aware of that.
Yes.
We'll have
So-
to see whether from this material
Yes, that any trial can be, my lord, proceeded, my lord. Not, my lord, whether he will be convicted or not, my lord.
yes.
That is, from that point of view, my lord, the statements so far recorded, my lord, as in also the, my lord, 2-3 statements I have found, my lord. There is some incident, my lord. And that is, my lord, prima
No,
facie.
Swami said there is marpit, no
Yes,
doubt about
Marpit
this.
is there, my lord.
And in the
First,
marpit,
he is
a
injured.
group has assaulted a group,
Yes, group.
a group or some
Yes,
student. And in that aggressor, Amit Mishra is omnipresent everywhere.
Everywhere,
His
my
name is
Yes.
Amit Mishra.
That is what
Others
clear.
30-40,
Yes.
one person says I
Yes.
can identify.
Yes.
Okay.
And my lord, secondly, my lord, 2 statements. One is of my lord, the victim himself, and another is my lord, my lord, now I have my learned friend, my lord, cited, my lord, that he is one of the witness to them because he is also one of the injured witness, my lord. He has also stated that they have been assaulted and he can identify, one he can identify, but others he can identify if they come before him. Now, one thing is that, my lord, why he has not identified, my lord. 2 things are there, my lord. The absconder accused, my lord, they have come much later, my lord, after the, my lord, filing of the search sheet, my lord. In search sheet, they are absconding, my lord. That is one fact, my lord. And another 2 injured witnesses are also there, my lord. That is one Mridul Suklavedya and Vishwanath Roy, my lord. Their statements are not in this LCR portion, my lord.
Whose
Yes.
statement?
This one, Mridul Suklavedya and Vishwanath Roy.
Who are they?
These names are revealed by, my lord, Devasis Das, my lord. They are succeeded witness, my lord.
They are
Yeah,
in the list their name.
In the
are-
list of
okay.
witnesses, my
Okay,
lord.
okay.
And their names appear in the statement of Devasis Das, my lord. It is-
Mridul Suklavedya and
Yes.
Vishwanath Roy.
Yes, there is a witness. One is Vishwanath Roy is the witness number 7, and Vishwanath and Suklavedya is witness number 8.
7 and 8, no?
8 man. Their
Okay.
statements are not here.
Mm.
They are also injured witness, man. They will also depose at the time of trial, man. What they have said before the IO, that is one part, man. But their statements is very much relevant at the point of trial, man. They can surely point out something on the trial, man.
Okay,
So that is
okay,
one-
fine, okay,
because
fine.
so
Now,
we
what
are, my
about
lord,
302?
302
Suppose tomorrow they come and depose. identify, there will be another aspect,
Yes.
whether
Yes.
TIP was there, not there, this will be
Yes.
that we may not go at this stage.
Yes.
Now suppose they say that all these are correct.
Yes.
All these are correct, and they identify that these are the person.
Yes.
Now, as Mr. Chaudhary has argued, what about 302?
302, my lord, it was charge, my lord, has been framed. My lord. Framed. So if at all, my lord, at any point of time, my lord, it can be altered.
No, see, we do not want any criminal to go scot-free.
Yes, my that
At the
is why.
same time, we do not want a person to face a trial without committing the error. Suppose there is no, how will you decide that
My lord,
argument? How that
my lord,
Mr.
one thing
Chaudhary
is
has
there, my lord.
argued, it's a 302.
If my lord, so far I understand, my lord, if the punishment, my lord, that is inflict, my lord, that carries a section, my lord, if my lord, the section carries more punishment than what is been, my lord, tried for, my lord, then only prejudice to the, my lord.
I understand. Suppose 303.
Yes, my lord.
30 is framed.
Yes.
No, 30 is not framed. It is
Yes.
325 is framed. Ultimately, it
then
was established that
302.
302.
Then, my lord,
Then
it will come.
it
my lord.
no.
Now, my lord,
It will
trial
be difficult.
proceed.
But
Yes.
if 30 is given, 325 can be given.
be given.
But
That is my-
without
that-
framing a specific charge, that person cannot be condemned.
what
That
in this-
that is one aspect.
Yes, ma'am.
But what about the materials?
Materials, my lord, so far my prima facie, so far I have found, my lord, from the statements, that, my lord, it is every probability that, my lord, the charge can be framed at least, my lord. I am not saying the other part, my lord. The trial can be.
You are saying we will not look into the materials whether it will lead to a conviction or not.
That is
It
what-
should be whether a trial can proceed on the
Whether
basis of this
on the
material.
prima facie trial can be proceeded or not, my lord. Because that is the law that has been laid down, my lord. Your lordship knows, my lord. I have, the decision is also there, my lord, where, my lord, in my lord Sajjan Kumar's case, my lord, my lord, charges are framed long after, probably, my lord, after 20 years, my lord. Then also, my lord, the High Court has
Where is
charged
it?
them, my lord.
Give the citation.
Yes, my lord. It is 2010 9 SCC 368.
Just a minute.
Yes. Where, my lord, just in one line, my lord,
2010
9 SCC 368. There is
368.
also a delay in framing of charge, but my says that a what is stated, my lord, a prima facie finding of grave suspicion is enough for framing of charge, my lord. And long delay in framing of charge.
No, wrong delay we are not
that
doing.
that I will not say. Because there is something that has been pointed out, my lord, because and the,
What it says, point of grave? Yeah.
my lord, prima facie finding of suspicion is enough for framing of charge, my lord. That, my lord. And my
Okay.
lord, another thing is well pointed out, my lord, that is, my lord, interest of the informants by going for the trial, and if any prejudice will be caused to the, my lord, the accused, my lord, that has to be balanced, my lord. Who will gain, my lord?
Any
That is-
judgment on that?
No, no, that same judgment, my lord.
Okay, okay, okay.
It is there, my lord. And that particular paragraph, my lord, that is there, my lord. May I read that paragraph, or
Yes,
my lord,
yes.
I can go to the other text, my lord.
You can go through. Just give me the paragraph.
Yes,
Today,
it is a paragraph, my lord, 27, my lord, there.
okay.
It is there, my lord.
Then
my lord, another, and paragraph, my lord, 16, my lord.
paragraph 16.
Yes, ma'am. And regarding the injury part, my lord, whether there is injury or not, my lord, from the bare perusal of the, my lord, report, my lord, it carries, my lord, cut injury in the eyelid and also aberration on the, my lord, left part of his, my lord,
Eye.
life, my lord.
That is initial injury.
Initial injury, my lord, that is been caused, my lord. And whether that can lead to septicemia, my lord, I have checked, my lord. It may be some infections from the cut injury, my lord. It has, my lord, the infection can come to the cut injury also, my lord, regarding the septicemia, my lord. So the cut injury can lead to septicemia because the medical, my lord,
PM report, it is stated, my lord, that cardiovascular, whether it's a cardiovascular regarding septicemia, following septicemia, and how septicemia is caused, it can be caused from cut injury also, my lord. So this is how the link I have found, my lord. And other my things there, my lord, in the postmortem also, my lord. There, my lord, some may lead to the postmortem.
These all dotates,
Yes, my lord.
all whole body.
Yes, my lord.
All dotates.
Uh,
These are because of the whole, or this is a septicemia is the infection of the multiple
Yes,
organs.
yes.
So therefore,
My lord.
that is the last stage.
Yes, petechial spots seen in the multiple.
All
Yes.
part. I have seen
Yes,
this.
yes.
I have read everything.
Yes, this.
All part. This
This
is
is
because
also a
of the
type of, my lord.
septicemia.
Yes, my lord. And this is also can be caused by, my lord, the injury also, my lord.
Okay.
Because it has a and my lord, another one thing is that there are two seizure lists in the, my lord. One is that before that, my lord, that is one Xerox copy.
Xerox, huh?
And another is from another person, my lord. That is there, my lord.
First
Two
is
seizure.
first father handed over, subsequently the aunt properly handed over the
Yes, yes.
the original copies.
Yes. And next, my lord,
Initially, the father handed it over,
yes.
but it was not accepted. Then
Yes.
the lady who's under whose possession the original was there.
Yes, that
was
is, yeah.
that person.
And another aspect, mother, FSL is there because we could figure out that this is the FSL, but cannot be read because that. So the search sheet also stated by it is the FSL is connected with it.
Case diary is given.
A case diary is there, my lord, but some parts are missing. That is what.
Okay.
Regarding the FSL and these two statements I have stated, my lord. They are also the, my lord, statements in the search sheet, my lord.
Yes.
And in the medical report, another medical report is there, my lord. That is, my lord, first he was examined, thereafter in the Silchar medical college. There the injury is, my lord, grievous.
The grievous, I have noted
Grievous.
it down.
Yes,
Routed.
that is the.
Injury is grievous.
Yes.
Yes. Ahmed,
It's important.
just summarize what should be your point of argument. We are not proceeding further today. We'll go to the other cases. Since we'll call for this statement, if available, of Midul Chakravarti, listed witness number 8 and 7, and FSL.
And my submission will also is that, Lordship, that the 7 and 8, they are cited witness and their statement is not here, Lordship. At least the prosecution should get the opportunity to examine them in the court. Due to default on the part of the investigating agency, Lordship, the informant should not suffer, Lordship. That is my first submission, Lordship. Because in the statement of Devashish, he categorically says that Midul Chakravarti and Vishwadip Roy were also injured and taken to SNC. So they are the injured witnesses. And second part, your Lordship, may I see that the
Why this? How police is doing investigation? Victim is not one. One died. Maybe for this reason, may not, maybe from other reason. But victims are more. Where? What about they are the victims? Where are their injury reports?
even their statements are not here, Lordship. They are cited as a witness in the charge sheet, but their statements are not here.
Yes.
And second thing, Lordship, that seizure list, which already your Lordship has perused, that at page 47, Lordship.
Just tell us. We will not go to the. Just I want your argument, summarize argument so that it ensures our head and we think of the both sides.
There already that seizure list is there, which shows that the deceased has written the name of these persons in a piece of paper, which was handed over to the investigating agency. Now, my submission to your Lordship is that to frame charges, the prosecution needs to show that there are some material to create suspicion against the accused persons.
Just a minute. Okay.
And this document, along with the witness that PW 7, charge sheeted witness number 7, 8, and 9.
Okay.
Are sufficient to presume that these persons are involved.
sufficient to suspect.
Suspicion, suspect.
Okay.
And evidentiary value of this piece of paper cannot be decided when at the time of discharge, Lordship.
Yes.
And for 302, the prosecution have to show that whether there is any proximity with the death of the person and the injury sustained by him in the incident.
Okay.
If Lordship may kindly for a moment turn to page 77. This is the statement of a doctor, Lordship, who initially examined the victim. Page 7, last three line, Lordship may kindly see. Due to the injuries, it cannot be certainly said whether the patient would live or not. So that proximity at this stage, Lordship, is there.
May I
So
just
where-
point out, my lord, that's a mistake in my lord translation.
Okay, just
That
that's why
to you, my lord, it is difficult to say whether the patient would live or my lord die.
In page 78, it is there. Lordship may kindly see that vernacular.
Vernacular is there.
উক্ত জখমে উক্ত পেশেন্ট মারা
মারা
যাইতে
যাইবেই না কি বাঁচিয়ে
বাঁচতে
থাকবে?
তাহা বলা বলা শক্ত।
It is difficult to say.
Difficult to say.
Whether he will survive or not, or whether he will
that-
die or not, it
yes,
should be
Yes,
that.
that question is there, that may lead to his death. That I'm just placing that
So,
part.
so
That
it may not lead, but
may
it
not-
may lead also.
Yes, here,
Yes.
here
Your
simply.
argument is he will say this is clear because they are not sure. You will say that this is not sure, therefore there is a suspicion.
He is the person who initially attended, Lordship. He is not the doctor who conducted postmortem, Lordship. At initial point of time, he examined.
Okay.
Just I'm relying on one judgment of Honorable Apex Lordship knows that the parameters were still for ready reference I'm submitting.
No, when we sit, we know nothing.
Paragraph 7, 10, and 12, Lordship. State of Gujarat has been Dipsika. Dilip Singh.
Okay.
Another judgment, Lordship, that I have given, small paragraph 4.1, Lordship, may I say.
Where? Mini trend, that word I have used.
Whether any sufficient material is available to proceed further. Here, Lordship, that injured witnesses are there, their examination is required. And their, whether their lordship evidence is sufficient to convict or not, they can, cross examination, they can,
Yes.
my argument before lordship is that there is material to presume that because the word 227, just I'm placing before your lordship. Two 228. If after the such consideration and hearing as aforesaid, the judge is of opinion that there is ground for presuming, the word here used here is presuming, that the accused has committed an offense, which, so these are there, so that okay. So there are the witness, injured witnesses, then they, when they say, lordship, that I can identify them, that has to be accepted, lordship.
Yes. Heard the parties. Yes, 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 yes.
Here there are ground for presuming. Whether, my lord, with these materials, there is ground for presuming that we are involved in committing the offense under section 302.
That is your case.
Presume.
You said that these are the materials, this cannot be the ground to presume. They say that these are the materials, don't go to the
We shouldn't go for
sufficiency
trial.
or legality of such evidence. But this evidence clearly creates a suspicion that you might be involved in this case. That suspicion is enough. This is the
And my lord, my learned friend has, my lord, rightly pointed that reasonable connection of date, proximity of time, my lord, with the injuries which he has suffered, my
So
lord.
your case is that yes, there may be proximity, but this is in 1 month.
1 month.
1 month. Then
my lord-
therefore you will rely on the last statement, third statement of the father, which gives the sequence how it happened, and it will nowhere shows that any seriousness. This will be, but they will say that this is the materials, whether this is sufficient, whether this can be treated as proximity or not, it is
It
to
is a
be
matter of
determined matter of trial.
because I have a judgment, I can place before.
For 302, my lord. There has to be, my lord, some injuries. And my lord, for those injuries, my lord,
That
date
is
has to be caused. by. But that is missing in our case, man. Where are the injuries, my lord?
We'll hear you. We'll hear you. Just this is a preliminary because will let us have the full satisfaction with these two. Heard the parties at length. During the course of hearing this court, after perusal of the scan copies of the record, it is found that the forensic report for the scan copies of the forensic report is not at all legible. First of, it is also seen that the statement of the listed witnesses, namely witness number 7 and 8, are not part of the scan copies sent. Full stop. Accordingly, the registry is to call for the scan copies of legible scan copy of
The statements are illegible. Entire scan.
no, that these are the other things we have done it.
Yes, it is required.
Yes, again it will get delayed because we have spent substantive time. We do not want to delay this matter further. People. Scan copy, legible scan copy of the SFSL report and the statement of listed witness number 7 and 8 recorded, if recorded under section 161 CRPC. If we have used
Yes,
the
I
if,
did not
may
be
not
recorded.
be 161 CRPC. As the matter has, full stop. Place this matter on within 2 weeks. Huh? 60 side case number to zero scan copy to side logo. Tare pora case number to aru police case number to DTV. Tetia Musumi, tell them that immediately. It will take 1 or 2 days.
My lord, may I
That's
have a
perfect.
prayer, my lord?
Yes.
Second, my
No,
lord,
no,
case,
is there any
second
stay?
case is
No,
fixed, my
stay
lord.
order is not there.
Okay, as the matter is extensively hard, and only hard and only what is remain is the consideration of the aforesaid three records. This court is of the view that the further proceeding should be stayed for the time being. Stuff accordingly, the further proceeding of so and so is stayed till next date. We will deliver this
Lord,
order.
may keep it as part or
Part. That's right. Otherwise, I could not have passed the stay order. Part. We have spent substantive time. It should not go. Ultimately, once again, whichever court is goes, you'll have to read these things because this is the materials.
Lord.
Musumi. Itu. Azin registry koi pala mapti pala. Itu what is this? Ika okal krapo kora hai. Date ko 16. Any problem on 16th?
No, man.
Just a minute. Musumi.
Can it be on 20th, Lord?
Yeah.
20th.
You prepone it. No, don't postpone.
13th, Lord.
13th.
13th.
Musumi. Mr. Chaudhary. Itu mari. Head. Huh? 13?
Evidence is there in.
Okay, tell us any date, any convenient date. We do not want to delay because our mind should also be fresh.
10th, Lord. 10th will be Friday.
Ahibo jano, record ahibo.
We'll do that. We'll assure that. Scan copies will assure that.
Let it be 10th.
10. Huh? Only tinta document. Who calls this? Call the person to the chamber. Yes.
Yes, sir. 10th. I'm obliged, Lordship.
Obliged. Judgment or bans to table of Tuba with I made a duta extra disile variable. Kiman itu? Yes.
May I please lodge?
Yes, Ali, what is this?
Lord, this may not quashing of FIR as well as my lord charge sheet, my lord. FIR is at page, my lord, 17, my lord.
17.
17.
Who is for the informant?
English.
Yes, case there is there.
LCR is there. LCR is there.
LCR is there.
Yes. Helpful.
Agreement मतलब page 31.
What is the name of the informant?
Kutubuddin madam.
Will Zubair?
Zakir is the petitioner. Zubair.
Who is Kutubuddin? Your client is Kutubuddin.
Kutubuddin, informant lordship.
After this, my lord, under agreement, my lord,
Hmm?
the petitioner, my lord, again, my lord, entered into agreement with the TDCL, my lord, page 33. Where, my lord, the informant was witness, my lord. Page 40.
Somebody was arrested also.
Petition number 2 was arrested.
Yes.
Lordship, two parts are there, lordship.
What is
420,
it? Two parts.
420 and 406. 406 is there, 420 may not be, lordship. Yes, entrusted with money, lordship,
Then
to invest.
money entrusted to invest. He has not returned.
Not returned.
File a civil suit. Why are you spending time here?
Therefore, 420 is not attracted, lordship.
406.
406 may, lordship.
Before the limitation expires, you have an agreement.
Lordship.
File a suit. Anything to be added? Tell us.
My objection may be recorded, lordship. That's why.
Heard. Mr. Ali, learned counsel for the petitioner. Also, heard Mr. Swenso, learned counsel. The present application under section 482 of the Code of Criminal Procedure 1973 is filed for setting aside and quashing the criminal for setting aside and quashing PRC case number 419/2023 registered under section 120 within bracket B/406/420/506/34 IPC corresponding to Murajar PS case number 86 of 2023. Full stop. The mere reading of the FIR is quoted here in below. The relevant portion of the FIR is quoted here in below. Where is the agreement?
Page 31, my lord.
Agreement was subsequent to FIR. Prior to FIR. Prior to FIR.
FI 2023.
Full stop. As regards the dispute, an agreement was also entered, which is part of the present proceeding, and such agreement is not in this execution of such agreement is not in dispute. Full stop. From the agreement and the FIR, it is seen that the grievance of the informant is non-return of the amount of money as promised under the as promised in the as agreed in the agreement dated 5th of March 2021.
Agreement is 1412. 2020.
14, where is that?
Page 31, my lord, left side.
Page
my lord.
31. What was 2021?
21,
Uh,
this
that-
is my lord agreement with the company.
Okay. Okay. 40, where is? Page 31.
14, 12,
31.
2020.
It is also not in dispute that such agreement was entered by the informant with the accused petitioner on the basis of an agreement dated 5th of March 2021 entered into between Assam Power Distribution Company Limited and the
Petition.
huh?
And petition number 1.
And the petitioner number 1. By the said agreement, the petitioner / accused was appointed as, what was his name?
Agent, my lord, for collection of
Appointed as agent for collection of
electricity bill, my lord,
electricity bill.
from the consumers.
Full stop. The agreement between the the petitioner and the accused reflects that the no, not petitioner, accused, and informant reflects that the informant invested certain money in the project. However, the accused petitioner failed to return such money and subsequently refused to return such money.
And threaten.
Threatening will come, return some money, full stop. Return some money. A bare perusal of the aforesaid FIR lodged by the respondent do not disclose any act of commission of any offense under section 40420 or under section 402. The
406.
406 and the and the dispute is essentially is civil in nature. By now it is well settled that and as held in the case of Paramjit Batra versus State of Uttarakhand, reported in 2013 11 SCC 673, that though the inherent powers of the High Court under section 482 of the Code of Criminal Procedure should be exercised sparingly, comma, yet the High Court must not hesitate in quashing such criminal proceeding which are essentially of civil in nature. Full stop. It is equally well settled that where a dispute which is essentially of a civil nature is given a cloak of a criminal offense, comma, then such disputes can be quashed by exercising the inherent power under section 482 of the Code of Criminal Procedure. Full stop. After a bare perusal of the FIR and agreement as discussed herein above clearly reveals that the dispute between the parties is primarily civil in nature. Such dispute involves as regards non-return of the investment made by the informant in terms of the agreement dated
14/12.
14/12
2020.
14/12/2020. 14/12/2020. No material is available on record, including in the case diary, to suggest to establish that that there was an intention to cheat the complainant right from the very beginning. Only for the reason that money is not returned back. Money taken as investment, only for the reason that money taken as investment under the terms of the agreement has not been returned, comma, will not necessarily mean that there is an initial deception to cheat the petitioner or petition. Full stop. The section 420 to bring home the prima facie case against in under section 420, some materials including a narration in the FIR is required that there was an initial deception in mind of the petitioner. So far, coming to the criminal breach of trust, there is also no material to suggest that such ingredients are available. Full stop. Therefore, in the considered opinion of this court, no case under section 420 or 406 is made out. Full stop. No ingredients is available either in the FIR or in the materials so far collected by the investigating authority on the basis of which the search sheet has been filed. First of all. Now coming to the offenses under section 506. 506 is search is there? Okay. 506. A vague statement was made in the FIR that, where is that? FIR page
70.
Yes, 70. That
Page 18, last paragraph.
Somewhere.
Page 18, last paragraph. While the informant demanded money, accused threatened it. That's one.
A vague statement that accused person has threatened the informant when money invested was when the informant demanded for return of the money invested. Full stop. The case diary also does not reflect any material, specific material to material as regards commission of offense of under 506 or any material regarding the threat given by the petition. Full stop. Therefore, in the totality of the matter, the present petition stands allowed, and accordingly, the proceeding PRC is set aside clause. Full stop. However, while parting with the record, it is made clear that the observation made is this present petition shall not debar the informant to seek his appropriate legal remedy, nor the observation made should be treated as treated to be a merit of claim of investment as discussed here in above, so far relating to the civil dispute among the parties.
One line, I have observed.
That will
Yes,
record it later. Mr. Ali submits that from the affair, no material is disclosed to proceed against the petitioner and to prosecute him under section 406, 420, and 506 IPC. Full stop. Per contra, the learned counsel for the respondent submits that when after the FIR is not always a gospel truth, and on the basis of the investigation, the investigating officer has filed a charge sheet, and therefore such criminal proceeding should not be stalled in exercise of discourse power under section 482 CRPC. I have given the excess considerations to arguments advanced by the learned counsel for the parties. The power under section 482 has been enumerated in the case of Hajalnar versus so and so. The relevant, the important features of such judgment is quoted here in below. Okay, next case. Yes.
482 application for quashing of the NI Act case.
Quashing of NI Act?
Yes.
Why?
Your Lordship, I have already made the payment within 15 days of receipt of notice through online banking. Thereafter, they have filed the instant case. Your Lordship may kindly peruse the demand notice at page 15. Relevant portion is at 16. Check number.
How do you know that this is against that or not against other due?
They have sent me the demand notice, only one demand notice. And for that, I have immediately remitted the amount promptly.
Where is the demand notice?
Page 15.
Huh?
Page 15.
Have you given any reply to their notice?
No, but Your Lordship, at page 19, I have sent the payment confirmation certificate to the concerned advocate who has sent me the demand notice. So he has replied, is it a part payment? When I expect you?
This is 50,000.
Yes. Demand notice was of 50,000.
Now, what is the stage of the proceeding?
For appearance.
When?
tomorrow.
Scan copy আহিছে?
Uh-huh.
Scan copies of the trial court record has not been received. Full stop. Accordingly, the matter stands adjourned and be listed on after 2 weeks, give a date. Registry to issue for reminder. Full stop. The learned counsel for the petitioner submits that an interim protection may be granted as the matter is fixed tomorrow. Full stop. This court under its order dated 10/4/2024 directed that prayer for interim relief would be considered on receipt of the scanned copy of the trial court record. In that view of the matter, though this court has not is not inclined to pass an interim order in view of the order dated 10/4/2024. However, a liberty is given to the petitioner to seek for an file an adjournment before the learned trial court below, and in the event below, take intimating the pendency of the present petition, and in the event such application is filed, the same may be considered as per law.
And sir, my only small submission which I'll also permission, my lord. The copy which is received, my lord, by me, my lord, is a half baked, my lord.
Okay, give it.
Page from 2 to 4 is
Give a
not
copy.
given. An objection may be filed. I'll file objection regarding this.
Okay.
Objection, may.
Okay.
Next day objection will be.
Uh,
Lordship, I point out 3 things, my.
Learned counsel for the responding about what files that he want to file an objection in this petition. He'll be at liberty to file.
My lord.
Give a copy. Good,
My lord. With all respect, with all respect.
Much of it.
You understand?
Lordships there.
Yes.
Adjourn for today, lordship, another date is fixed, lordship.
What is this?
The lordship, the maintenance case, lordship.
Please this matter on the prayer of the learned counsel for the petitioner, list this matter after 2 weeks.
My lord, we have filed objection, my lord, in the form of IA, my lord, that is number 380/24, my
Okay,
lord.
it is
Maybe-
submitted that respondent number 2
Yes,
has filed an IA being IA
IA
number
criminal 380/24.
Registry to verify and list the IA along with this petition on the next date.